Audio check 1 2. Live stream audio test 1 2.
Inquiry is resumed. Anything anybody wants to bring to my attention?
Not attention, sir, but just in terms of timetabling, I imagine Mr. Tiley might be a while in, Chief. I won't be that long in cross-examination, but it's 2 o'clock. I'm just thinking in terms of finishing this topic today, I just wonder to what extent we might be able to take the schedules as read. The comments are fairly comprehensive. I don't ask that question to be answered now, but perhaps it's something we could think about, because to go through them line by line, when you've got quite detailed observations set out in the schedule, you do wonder what would be added. But anyway, I just sort of float that idea, because otherwise I can see us going into tomorrow with this topic. But
Okay.
if I just stop there, otherwise we will go into tomorrow with this topic.
Yep, okay. Well, we'll bear that in mind. Can obviously canter through the schedule at a reasonable pace, I'd expect. We've touched on a lot of it already, I think. I'd like to finish it. I'd like to finish today. I mean, what is everybody amenable to sort of hanging on to finish the matter today?
Yes, sir.
So if we have to stay a bit later, I'm quite happy. Okay. I don't think we will. If we get on, so I'll get on. Mr. Garvey, please will you call your witness, please?
Yes, thank you, sir. Well, with that, let's fly through this. So I'll introduce you to the inquiry. Your name is Neil Tiley.
That's correct.
And you set out your qualifications and experience and your background in your proof of evidence at page 7. And in particular, you tell us that you have given evidence at a number of Section 78 inquiries and the examination of the core strategy and the site allocations plan in this local authority.
That's correct.
So I'm going to take his evidence, his qualifications as read, if you're content, sir. We obviously agree that the council don't have a fibre supply and that they haven't had a fibre supply for 8 years.
Correct.
But it's the council's contention that things are improving and that the direction of travel is optimistic. What's your view?
Well, I suggest precisely the opposite, sir, for a number of reasons. Firstly, sir, there is no trajectory beyond 2026, and so there is simply no evidence to suggest that the situation is either improving or worsening, and therefore there's nothing that you can rely upon to reach any conclusion on the direction of travel, is the first point. Now, we do, however, have a number of contextual indicators, sir, which point to a direction of travel, if you like, sir. The first is that presented by Mrs. Richards in Table 8 of her proof of evidence, which is the historic housing delivery test results in the way that she's calculated them.
Do you want us to turn that up?
Yes, I mean, it might be useful to have it to hand, sir. The housing delivery test is a measure of past performance.
Just let us... so table 8, so it's page 25 of her proof.
Yes, precisely, sir. Sorry.
Yep, carry on. We were looking at that this morning anyway, yeah.
Yeah, so the housing delivery test is a measure of past performance. It therefore provides no gauge as to the direction of travel in the future. Furthermore, Mrs. Richards has calculated prior to the introduction of the housing delivery test, and as we heard this morning, in a way which doesn't comply with the housing delivery test because, for example, for the period 2010 to 2015, Mrs. Richards has assessed against the housing requirement which was not adopted at that time, and therefore the housing delivery test couldn't have been assessed against that figure at that time. Furthermore, sir, the housing delivery test changes the basis of assessment on an annual basis, and particularly so in the last 2 years, where the government has introduced adjustments to take account of the effects of the pandemic. Therefore, any longitudinal analysis of the results of the housing delivery test is simply not comparing apples with apples, it's impossible to draw a longitudinal trend from them. But if you were to do so, sir, and I don't recommend you do, I've corrected the figures of Mrs. Richards in my rebuttal proof of evidence, sir.
Let's get that up.
Table 4.1.
So it's page 7 of your rebuttal?
Yes, precisely, sir. And this presents the figures since the introduction of the housing delivery test results, both with and without the current adjustment of the government to take account of the effects of the pandemic. So the only way in which you can compare apples with apples is to do the assessment on a consistent basis year to year, which is the bottom row of that table. And that shows that even using housing delivery test results, which only provides a direction of historic travel rather than future travel, it shows that the figures have wavered between 73 and 79% if you compare on a like-for-like basis, sir. So I say that the use of the housing delivery test is inappropriate in the first instance, but even if you were to rely upon it, there's no clear trend in any event. In Table 9, however, sir, of Mrs. Richards' proof of evidence, we do have a meaningful longitudinal assessment, because there, sir...
Let's just grab that. So Table 9.
That's page...
27.
27. We have figures which can be compared on a like-for-like basis, and they demonstrate that the total supply available to contribute to the 5-year land supply has decreased year on year for the last 5 years. With a continuing reduced supply, sir, you would expect the 5-year land supply position to reduce year on year. Now, again, it's historic, and clearly there's the opportunity for the council to approve a substantial number of sites this year.
I'm so sorry to interject. Just that last point you said, with a continued reduced supply, you'd expect the 5-year supply. What do you mean with continued reduced capacity on these sites?
Yes, sorry. A capacity of total sites has reduced from 12,003 to 11,018. With a reduced total capacity, you'd expect a lower 5-year land supply to come out of the other end. Now, clearly, sir, there's the opportunity for the council to approve a substantial number of additional sites this year to try to get back to the 12,003 position of a total capacity, but that would require the approval of 1,000 homes, and then we'd only go back to the position in 2017 when the council were unable to demonstrate a 5-year land supply, sir. Sorry, were unable to demonstrate a 5-year land supply. So all of the there isn't any assessment of the future direction of travel to which you can afford any weight, and the only contextual indicator indicates that the position will worsen, if anything, sir. I think that's the end of that question, Mr. Garvey.
Thank you.
I hope.
The council, and it'll be put to you, that council say, well, in 18 months' time, we could have a new local plan, and that could restore the 5-year housing land supply. So isn't any shortfall that's currently in existence only going to be short-lived, given in 18 months' time it could be solved?
Clearly, sir, a new local plan could restore a 5-year land supply, but the reliance upon such a local plan is in itself an admission that the policies of the adopted development plan have been so ineffective as to need replacing in their entirety, and that would bear upon the weight to be afforded to the adopted policies. It would also necessitate the identification of a significant number of sites through that emerging local plan, potentially including in fact, we've heard from Mrs. Richard that it will include greenfield sites, such as the appeal site. So again, it provides a further indication that the council's proposition that a 5-year land supply may be restored at some point in the future will be dependent upon sites such as the appeal site. Thirdly, sir, I understand that the parties are agreed that the emerging local plan can only be afforded very limited weight, and therefore any proposition that it will restore a 5-year land supply can similarly only be afforded very limited weight. And fourthly, sir, although this might stray into the evidence of Mr. Wakefield, I understand that the 18-month time horizon for that is very optimistic, given that it's not an uncontroversial plan. Indeed, sir, since the consultation draft was published, the minimum local need of the housing method has increased by 800 homes. So already the council will need to identify another 800 homes to be delivered over that plan period before preparing their next draft plan for consultation. Then, sir, as I allude to in my proof of evidence, there's also the controversy of the unmet need of Bristol. So there are a number of factors which, shall we say, diminish the weight to be afforded and are likely to delay the point at which a new local plan may come forward and may restore a 5-year land supply. Thank you, sir.
Just, you deal with a 5-year supply up and down the country. How novel is this suggestion from the local planning authority saying, oh, don't worry about us, we've got a plan on the horizon that will solve it?
I mean, because Hallam Land, sir, requires us to have regard to the direction of travel, as in how long the shortfall is likely to persist, in every local authority where there is currently a shortfall, the arguments tend to either fall into two camps. The first is that the shortfall is minimal and we've got this site in the pipeline that we're going to approve and therefore next year a 5-year land supply will be restored. That's not the position in this LPA. The other proposition of an LPA is that, don't worry, we'll adopt a local plan at some point in the future and everything will be rosy then. So it's a common thing and obviously something that's available to every local authority, but all it does is take away from the ineffectiveness of the adopted development plan and defers meeting the needs which have gone, in this authority, have already gone unmet for 15 years to a future plan period, sir. Thank you.
The other suggestion about meeting supply was that the council could grant planning permission on sites outside of settlement boundaries, but in accordance with the development plan through policy CS32. So the reference was sites of up to 25 dwellings or 50 dwellings, depending on their location. What do you take about that? Is that credible, that would be achievable to remedy the council's supply shortfall through development plan in that respect?
Well, the starting point is that the operation of those policies, sir, has, by any measure, been ineffective to date. We're agreed the council is unable to demonstrate a planned period supply or a 5-year land supply. So I would suggest that the reliance upon those policies is misled. But in any event, sir, even on the council's case, which I wholly disagree with, there's a shortfall of over 1,500 dwellings to be addressed in what is now 4 years of the planned period. Now, if it's, as I understand the council's cases, is to be suggested that a sufficient number of sites will be approved under those policies to deliver 1,500 homes in 4 years, that's going to require an incredibly large number of sites, on sites such as the appeal site, I would suggest, sir.
Thank you. Next point, I want to talk about the greenfield sites on the edge of settlement boundaries. So in your proof of evidence, if you would please, and we're going to turn up paragraph 5.17. Tell me when you've got that.
Yes, I'm there.
Thank you. And at 5.17 and 5.18, you tell us that there's at least 859 homes. So I've been on unallocated greenfield sites outside of settlement boundaries that in the council's current supply That's how many that they've got. And that you haven't looked at small permitted sites and windfall sites, you tell us in the footnote. And similarly, you tell us at paragraph 5.18 that of that figure, 628 of them were granted on appeal.
Correct.
So we know that the council's supply, there's a proportion of that which is reliant on unallocated greenfield sites outside of settlement boundaries being granted on appeal.
That's entirely true, yes.
What, if anything, should the inspector take from that?
Well, so you will see from that 2 points, really, that notwithstanding the fact that the policies which the council rely have been effective to some extent, as in additional greenfield sites outside of settlements have come forward, that has largely been as a result of appeal scheme, sites being granted on appeal rather than positively determined by the council. But even with that, sir, it remains the case that with that 859 additional homes, the council remains unable to demonstrate a plan period or 5-year land supply.
Thank you. The next point I'd like to ask you about is just the council in their Scott schedule, they are relying on delivering, on average, 1,440 dwellings per annum. And we tested to what extent the council, that's credible. Just looking at your proof of evidence, if you would, please. You provide a table, figure 9.1, I believe, from memory. 9.2, sorry, it's page 40. Can you see that?
Yes.
And you can see there that, sorry, I'm so sorry, it's not that table, it's at the table I'm looking for is where
you... Figure 9.1 on page 38?
That's the one, thank you. Yeah, you demonstrate the delivery in terms of the previous years. And you can see in 2007, 2008, the council exceed the figure of 1,400 homes.
That's correct.
But in no other year did they achieve that figure. So
not by a very substantial margin, correct.
How credible is it for the councils to say, well, on average, every year for the next 5 years, we will deliver 1,440 homes, when they've only achieved that once in their history since 1981?
Well, it's patently unrealistic. I mean, you just look at this trajectory, sir, and it shows how unrealistic the council's position is, to my mind. The council's position is that housing delivery in each of the next 5 years will be substantially greater than anything which has been achieved in the recent past for any consecutive block of years, at least. It's, as I articulate in paragraph 9.39, it's 62% greater than the average achieved over the last 40 years. It's almost double that achieved in the last 10 years. And whilst it has been achieved once in 1 year, it's never been anywhere near achieved over more than one consecutive year, if that makes sense.
So they have to achieve that, and even if they do they have a 5-year supply, even if they were to achieve that?
No.
Thank you. Lapse rates, what, if anything, do you want to say about lapse rates?
Well, I think very briefly, sir, we heard from Mrs. Richards that it's true that a proportion of small permitted sites will not be implemented. And yet Mrs. Richards sought to suggest that nevertheless the full capacity arising from small permitted sites will come forward. Now that inherently assumes that additional small sites will gain planning permission, which simply double counts the windfall allowance of the council, sir.
Thank you. Have you seen any evidence from the council which assesses, here's what we've granted on small sites, and here's the extent to which they've actually been implemented?
There was, in support of, I think it was the site allocations plan many years ago, which led to the council, well, it was miscalculated, and on that miscalculation, the council identified that 10% of small permitted sites were not implemented. Had it been correctly calculated, it would have identified that 24% of small permitted sites will not be implemented within 5 years. And that's broadly consistent with the position in every other LPA that I know that robustly assesses the non-implementation rate, because they all apply rates of between 22 and 33%, sir. But to this inquiry, and in fact there is no more recent evidence that I'm aware of as to the implementation rate beyond that which was considered back at, I think it was the site allocations plan examination, it might have been the core strategy remitted policies examination, but one or other.
Yeah, I think you set that out at paragraph 11.4 of your proof, please, page 43.
Yes, precisely so.
And you give us the footnote 32, where you cite what's happened in other authorities when they have actually examined. Thank you.
Exactly so. And just for context, I was involved in the Gloucester, Cheltenham and Tewkesbury examination, and they calculated the lapse rate, sorry, the non-implementation rate on precisely the same basis as North Somerset had. The inspector engaged with that consideration and concluded that the lapse rate had been miscalculated by the LPA, and that it, in those instances, I think it was between 22 and 23%, the correctly calculated non-implementation rate.
Thank you very much. Anything you wish to say about affordable homes?
Well, the sole issue in dispute, I think, appears to be the threshold against which you assess the delivery of affordable housing, sir. I assess it against the need for affordable housing because that obviously identifies the need for affordable housing, which is material to the weight afforded to the provision of affordable housing. The council, however, assess against the housing requirement, which, even on that basis, there has been a shortfall, though obviously a lot lower shortfall, which goes to the weight which one would afford to the effectiveness of policies in meeting the minimum affordable housing aspirations of the local plan. So we're each using different indicators, each of which go to different points.
My own friend, I think, is going to be relying on a judgment, and we'll talk about that. But irrespective of what the council are required to do by national policy, to what extent does that diminish the need for affordable homes in this district?
I'm not sure I fully understand the question, but we are agreed that there has been a shortfall of 8,700 affordable homes relative to the need for affordable housing, and that must be a material consideration for you, sir, I would suggest.
If the council say, well, we are not required to meet that.
Yeah, that's a policy requirement rather than reflective of the need. The need for affordable housing will clearly be material.
Thank you very much. I've got no further questions, unless there's anything further you'd like to bring to the inspector's attention.
Not from my perspective, Mr. Garvey. Thank you.
Very much.
You okay to carry straight on?
Certainly, sir.
Yeah.
Thank you very much, sir. Good afternoon, Mr. Tully. Now, if you could just take up the framework, please, at paragraph 11.
Yes.
And I know you're familiar with footnote 8 and the remainder of that paragraph, so I won't waste time reading it. The short point is this, I hope you'll agree with me, that whatever else is true about the absence of a 5-year housing land supply, it is not the case, is it, that the absence of a 5-year housing land supply makes an unsustainable site sustainable?
That's probably a question for the planning witness, but that's inherently correct.
Yeah, well, I'm just wondering what the point of this evidence is, you see. So the point is that if there is not a 5-year housing land supply, that does not mean that an unsustainable site becomes sustainable, does it?
Well, no, and nor could it.
Good.
Correct.
Having agreed that, let's move on. Hallam Land Management, which is CD 44. Would you like to turn to paragraph 51, please, which is on page, pages aren't numbered, but it's paragraph 51, if you wouldn't mind.
para 51, certainly.
And when you get there, let me know.
Yes, I'm there.
Now, before we dig into this case, I ought to do things properly. We see this is a decision of the Court of Appeal. It dates from July 2018. I'm looking at the first page. We are going to be looking at the judgment of Lord Justice Lindblom, so a judge whose opinion is not to be ignored, at least not in any sense anyway. And we go to paragraph 51, and we see there that the judge talks to us about, or rather tells us about, the way in which one uses the 5-year supply figure, and in particular what weight, or rather how one approaches the question of weight to be attached to a shortfall when a shortfall is found. And I'm going to read the second sentence. But the weight given to the benefits of new housing development in an area where a shortfall in housing land supply has arisen is likely to depend on factors such as the broad magnitude of the shortfall, how long it is likely to persist, what the local planning authority is doing to reduce it, and how much of it the development will meet. So, I mean, your evidence is obviously focused very much on past history, and it's obviously focused very much on where we are, and that's fair enough. But what I would like to do is just think about where we're going, because that, according to paragraph 51, is what the inspector needs to particularly bear in mind when he comes to attribute weight to the shortfall that we concede exists. So, the broad magnitude of the shortfall, the broad magnitude. Now, you say, I think, just under 3. The council says around about 4.9. There's obviously a difference between us. But just so I can understand the consequences of perhaps you being right and us being wrong, well, how do I use, in practical terms, your conclusion that the figures, I'm going to put it nearer 3 than 4. How do I use that in practical terms?
Well, clearly there would be a 3-year, again, this goes to planning more than myself, but a 3-year land supply would be indicative of a greater need for housing currently, such that the weight afforded to the provision of housing would be greater, and the weight afforded to policies which are restricting that supply of housing would be reduced.
Yeah, but how do I use it in practical terms? You see, the council has conceded a shortfall, and it's accepted that the shortfall is material. And I suppose that you would say that a 3-year supply is a material shortfall. And we're saying, well, whatever supply we're able to demonstrate is a material shortfall. So where does your evidence take us? I'm just curious how we're going to use this in practice, Mr. Tyler.
Because, okay, sorry.
To the planning witness, but the question really is, how does this inform your planning balance? And given this witness isn't conducting the planning balance,
well,
it's a question for Mr. Wakefield.
Well, I mean, it can be asked of Mr. Wakefield, but Mr. Tiley is very keen to tell us that it's a 3-year rather than a 4-year supply, or to that effect. And I'm just wanting to understand why that matters so much. So help me if you can, and I can ask Mr. Wakefield, and I will do, since you invite me to, but I'm interested in the 5-year supply expert's view. This extra year that you knock off, how does it help us?
In supply terms,
Yeah. Well, the council's case is, I can't remember, but from the top of my head, there's a shortfall of roughly 100 homes, 100 and something homes against a 5-year requirement, whereas my position is that there's a shortfall of roughly 3,000. Clearly, the contribution of any scheme must be viewed in the context of that shortfall. There is a very material difference between the two parties, which will inform the weight you afford to that housing and the weight that you afford to the policies that have given rise to that position.
Yeah. All right, well, I'll ask Mr. Wakefield to explain this difference in weight more carefully. But for our purposes, let's take the matter a bit further by reading on through paragraph 51. So we've got this difference between us, the broad magnitude of the shortfall. We'll argue about that. in the session that follows, how long it is likely to persist. Now, I think what you said in chief, and you correct me if I've got this wrong because I'm going to paraphrase, is that if there is a new local plan, I think your evidence was that might correct the shortfall. Is that what you said?
It's possible that, in fact, probable that if it's found sound, a new local plan will demonstrate a 5-year land supply.
Well, that's the point I wanted to put you, really. The plan won't be found sound unless it does deliver a 5-year supply, will it? Because as you will know as well as me, in order to be found sound, a plan must accord with the policies of the framework. And we can go to the relevant part of the framework to demonstrate that proposition, but I hope you'll agree with it.
Yes, I would agree, but there are a number of ways in which it could do so. So, for example, it could have a phase requirement, such that the 5-year land supply is being assessed against an artificially low requirement at the start of the plan period. There are a number of mechanisms, which means that, and I don't know if this is being proposed in North Somerset, but it's likely that if the plan's found sound, it will demonstrate a 5-year land supply. Whether it rectifies the current position through a phase requirement or whatever else means that it could be found sound, notwithstanding the fact it doesn't actually address the needs that have gone unmet for 15 years.
Well, let's just stick to the ambit of paragraph 51. The first point is the council is preparing a new local plan, you know that.
Yes.
Secondly, the evidence of Mrs. Richards is that the council anticipates, the LDS demonstrates, that it expects adoption in 2023. Whether it happens or not is another matter, but that is what is currently being planned.
That's what I understand.
And
the
I
council
don't read your evidence, or indeed Mr. Wakefield's evidence, as indicating any fact or matter which would show that that timetable is unrealistic. You can say what you want, but there's no evidence at the present time, I don't think, that the plan is slipping. Is that correct?
I don't present evidence on that. I don't know about Mr.
Well, if
Wakefield.
Mr. Wakefield does, he could tell us about it, but I'm not aware of any. Good. So on the basis that the plan proceeds and is adopted on target, that will be before the end of the core strategy plan period, won't it?
Yes, it would be.
Yes. And to the extent that there is presently a shortfall, that shortfall will be accounted for in the new local plan, won't it?
Yes, it will be.
Yes. So that what we can be sure of is this: the new local plan will plan to not only meet the requirement over the forthcoming plan period, it will also plan to correct the shortfall as part of that.
Yes, but as I say, if it proposes a phase requirement, it will delay doing so. But there is a prospect that the emerging local plan, if it follows the timeline set out by the council, then yes, a 5-year land supply would be likely to be restored before the end of this plan period. However, we're all agreed that the weight afforded to that emerging local plan is very limited, and therefore the weight that you can afford to that proposition must similarly be very limited, because it will be dependent upon the policies and allocations contained within that local plan.
Well, I'm not sure that as a matter of logic those two propositions follow, so we'll explore that just a little bit. The plan will be found sound if the examining inspectors or inspector concludes it is justified, supported by a proportionate evidence base, and otherwise in accordance with the framework. That's right, isn't it? I mean,
assuming the duty's been met and everything else, providing it meets some procedural guidance and accords with the test of soundness of the MPPF, then yes.
So all of those, so the inspector being satisfied that the strategy is one that will deliver a 5-year supply and is in other respects sound, I just wonder why it is you remain concerned about the way in which the requirement will be met. And in fact, the matter is whether it's phased or not. It will have to be found sound to be adopted.
Yes. So the weight that you afford to the supply of housing and to policies are in part informed by the length of time a shortfall is likely to persist. Now, firstly, the proposition of the council is that through an entire replacement local plan which abandons all the current policies and replaces them with new policies, a 5-year land supply will hopefully be restored. So that initially engages the point that the weight afforded to the adopted policies would have to be reduced substantially. The second point that it goes to is the weight afforded to the provision of housing. If the new local plan has a phased housing requirement, it's deferring meeting the needs which have not been met for 15 years already. And therefore, if a phased housing requirement or some such other mechanism to defer meeting housing needs was found to be necessary in order for the plan to be sound, that would remain a material consideration to the weight afforded to the supply of housing.
All right, now then, just a couple more points along these lines, but then we'll move on. What the local planning authority is doing to reduce the shortfall next. What it is doing to reduce the shortfall, and I hope you'll agree with me, it's doing it fairly well, is to secure the delivery of the strategic sites at Western Villages. A couple of questions here flowing from that general proposition. First, we can agree, can't we, that delivery from Western Villages was initially slow. We do have a couple of discrete sites delivered early on. We heard about those in Mrs. Richards' cross-examination. But on the whole, it's right to say, isn't it, that the strategic sites were slow to get going?
I wouldn't say they're slow. They've hit kind of 200 homes per annum, which is kind of broadly consistent with what you'd expect. I think I previously suggested, I can't remember what I said at previous inquiries, but the supply from these sites, it doesn't, to my mind, indicate that they've been slow. It indicates that they've hit their peak and are now trundling along at a fairly reliable average of 200, 250 dwellings per annum.
Yeah, they've hit their peak. When do you think they hit their peak?
Well, if we go back to my proof of evidence,
yeah.
I've got the trajectory for the sites.
Where would you like us to go?
In figure 13.3, page 74.
Yes.
And you will see from 2014-15, they've had a fairly reliable and consistent contribution to the supply year on year, except for 2019-20 when the supply dropped off for one reason or another.
That's right. So looking at that figure, we see that in 2012, when the plan was adopted, less than 100 dwellings, builds up to a peak in 2016-17, and apart from the COVID year, supply has been steady ever since.
Exactly.
Yeah. And so there was a hiatus for a few years whilst the plan unwound. But come 2016-17, those sites make a contribution. You're confident, are you, that that contribution will be maintained around the level we see on page 74?
Well, when you have a site of this size, well, a strategic scale site, that the typical kind of profile of delivery is that you build up from a lower levels to a kind of peak. You plateau it around that, and there will be some variation around that until it builds out. That's a fairly standard profile for large sites.
Well, the reason I ask is I could see a blue line and a green line, you see.
Yep.
And I understood the green line to be that supply you thought was deliverable. You thought was deliverable.
Yes, it is.
Yeah.
I should say on the green line, sir, this is one of the quirks of national policy in that because Category A sites are considered to be deliverable, I've just adopted the council's trajectory for the Category A element of this, and therefore you get that artificial peak in the short term, whereas Category B sites, the residual parts that I've outlined, are only considered deliverable where you have clear evidence, and therefore mine has got an artificial peak. But really, I'd suggest that it averages out around the middle of that green line at approaching 300 dwellings per annum.
Yeah. So on your assessment of the evidence, looking towards the future, we can contemplate partly an improvement in delivery over and above that indicated for 2021, along the lines of your green line. That's what we can
Yeah. So I think I make an allowance for 1,601 dwellings from this source of supply, which over 5 years, I won't be able to do the maths, is about 530 something, isn't it?
So
Sorry,
an improved position is the
330.
is the evidence I can record from Mr. Tiley. You don't agree with Mrs. Richards' view, but you're at least optimistic about the future from these strategic sites.
Yeah, I'm saying that the average will increase from between 200 and to what's that, say 270 to about just over 300 per year. But that's in the range of variation. You know, I'm being optimistic with Western Villages. You're entirely correct, Mr. Leader.
Good. And can I just ask you, what do you attribute the council's improved performance to? Why is it, do you think, we're going to see that improved performance? What is it that underlies the trajectory of your green line?
Why will the council's performance improve?
Well, no, let me help you. You've indicated a more positive trajectory via your green line. What underlines your view on that improved situation?
Again, it goes back to a quirk of national policy in that it identifies that Category A sites are to be considered deliverable kind of regardless. So what I'm doing is I'm assessing a realistic prospect of delivery rather than what actually will happen. So therefore you have obviously there's a realistic prospect of more than what will happen at being achieved, and that's what's reflected in my green line.
Well, can I help you in this way? The reason that green line shows an improved situation, indeed Mrs. Richards' blue line shows an improved situation, is that what has happened in Western Villages and strategic sites more generally is that the necessary infrastructure required to support an increased rate of delivery is now in place and supporting delivery. That's right, isn't it?
I agree that the infrastructure's largely in place, but notwithstanding that, delivery rates have hovered around the 200 to sub 300 mark, and I'm giving the benefit of the doubt, as I repeatedly identify through my proof of evidence, to the council, and therefore identifying a greater supply over the next 5 years, which is still, I can't remember what it is, but roughly 2,000 less than that which arises from the council's, to my mind, impossible blue line.
Right, next, page 40, please, of your proof. Now, we see there figure 9.2 and table 9.1, which were put to Mrs. Richards, I think, as an indication of the council's poor past performance. That's a general idea. What I'd like to just explore with you is what these tables actually mean. So if we look at table 9.1, we see at the foot of that table, Sandford, Backwell and Western Business Park, the view of an inspector, rather the inspectors, on the deliverable supply in each case. Do you see that?
Yes.
And the inspector concluded that a certain level of supply was available. And then we see the actual completions achieved.
Yes.
And the two are different.
Yep.
But the point is this, if I can put it to you like this, it's the council's job, isn't it, to secure an adequate supply of land for housing.
Yes, it is.
It's a developer's job to build houses.
It is, but
Yes.
it's the council's responsibility isn't just to identify a sufficient supply, it's to identify a sufficient supply with a realistic prospect of delivery, taking account of the market conditions, the infrastructure required, the developer's intent to deliver. Various factors feed into that. It's not sufficient, as is proved across the plan period, to just identify a supply which exceeds the need. What you also need to do is take account of the proportion of that supply for which there is a realistic prospect of delivery.
The point is really this, if you'll forgive me, that 3 inspectors identified a quantum of land which met the NPPF's framework, which met the NPPF's definition of what is deliverable. That's right, isn't it?
In their judgment,
Yeah.
they had, but as it's proved, they had accepted the council's position on a number of sites, and the result of that is that their positions were circa twice as great as that which has actually been delivered.
Actually, Mr. Tyler, there's another way of looking at it, isn't there, which is this. When the inspectors determined that that quantum of land was indeed deliverable, they were right. What, or rather the root of the failure, to the extent there is a failure, to deliver enough housing in this district is down to your sector, which is the builders. The builders have enough land. The fact is they simply haven't got on and built, have they? That's the problem here. It's not the council at all. We've delivered a supply to there. What the house builders haven't done is use it.
Sorry, I think 3 points that arise from that. But the first observation is my sector isn't the house building sector. I'm a planning consultant and will represent anybody. The second is that the inspectors and the council, in exercising their planning judgment, at this point in time were doing so, I seem to recall, under the guise of St Modwyn, which was a High Court judgment, sir, which, in fact, a Court of Appeal judgment, I think, which seemed to support a very optimistic but nevertheless realistic prospect of delivery. And we, up and down the country, we ended up with a lot of assessments where the supply was significantly overinflated, as has proved to be the case here. But even let's suggest that the proposition of Mr. Leader's correct, that there has been a sufficient supply, but it hasn't been delivered and the fault lies with the development sector. We now sit here and think, how do we assess whether a site has a realistic prospect of delivery, having mind to the role of the development sector within that? And we'd reach exactly the same conclusion, that the supply identified by the council needs to be moderated significantly to take account of the role of the development sector.
Well, you see, does it really? Because if there is a supply, and you're sitting there ready to build, the developers aren't building it, it does raise the question, doesn't it? Should unsustainable sites be brought forward? So let's look at that. Let's look at that together. First of all, do we need to bring unsustainable sites forward? Let's explore that. You will be aware, because you've done other inquiries in this area, that when Inspector Jonathan Ball recommended the core strategy be adopted following the reconsideration of those policies that were remitted, he did so on the basis of policy CS 28, 31, 32, and it was the 30. Should incorporate a flexibility allowance so that you could get, so rather that the situation is that at the edges of Western Supermare, Porter's House, Nailsea, Clevedon, and the 9 service villages, it is possible to secure planning permission for sites outside the secondary boundary, provided that the range of criteria are met. That's right, isn't it?
That's right.
And Western, that admits sites up to 75 units, so Clevedon, Portishead, and Nailsea up to 50, the 9 service villages up to 25.
Correct.
And I think your evidence is that the 1,500 unit shortfall that you anticipate between plan supply and the requirement to deliver that plan supply over the remainder of the plan period is capable of being met by this flexibility allowance. Yeah?
Sorry, just one point of clarification. The 1513 is the council's position. My position is a shortfall of 4,393.
Well, let us stick with the council's position because that's what was explored with Mrs. Richards. We've got this 1,500 dwelling deficit to make up by the end of the plan period, yeah?
If the council's trajectory is achieved, yeah.
And let's think, we're in 2022, so we've got 4 years to go. So it's around about 380 dwellings per annum, isn't it? I think that's right.
Yeah, but roughly, apart from we're shy of 4 years, we've got 3 3/4, but yeah.
I think that's right.
Yeah, it is roughly 380 if it's divided by 4.
Yeah. So, out of interest, what has been the unplanned delivery at the edge of those settlements since the remitter policies were adopted by the council?
Sorry, I didn't understand the question,
Well,
Mr.
We
Lee.
have policies CS 28, 30, 31, 32 with their flexibility analysis. Adopted by the council, I think, in 2018, following the Inspector Board's examination. I'm just wondering what has been the adventitious supply under those policies since that time, in terms of permissions granted locally and on appeal, do you know?
Well, a number of corrections and observations, but no, I don't know. The plan was adopted in 2017 rather than 2018, as you said. And the national policy, paragraph 23, it requires that plans plan for and allocate a sufficient number of sites. It's not to defer to policies coming forward to supplement the supply. Development plans in and of themselves are meant to plan for and allocate a sufficient number of sites.
Thank you for that, but let's just take this in stages.
Okay.
First of all, we can all agree, can't we, that Inspector Bohr recommended the adoption of the policies I have referred to in accordance with the NPPF. You're not suggesting that Inspector Bohr did anything contrary to policy otherwise, or indeed unlawful, are you?
No, but he was dealing with the previous NPPF, which didn't have that requirement of national
Well,
policy.
he was dealing with the NPPF, it's just not the current version.
Yeah.
Are you going to tell me in a minute that the NPPF as presently framed is materially different from that which Inspector Bohr was operating under, such that he couldn't do today what he did in 2017?
It's materially different in a number of regards.
Yes,
Paragraph 23
that's
is...
not the question.
I was
question
going on
is-
to...
well, hang on, let me ask the question precisely, but I'd like a precise answer. Inspector Bohr recommended the adoption of the flexibility allowance under the version of the NPPF, which was, I think, promulgated in March 2012, right? Now, the precise question is this: are you saying that under the relevant paragraphs of the NPPF today, Inspector Bohr could not have done that? Straightforward question, straightforward answer, please.
It's a hard one to answer because that's kind of would require the entire evidence of the local plan, the site allocations plan as it was adopted, the core strategy as it was adopted, to be tested again to see if there was sufficient evidence to do that. But the new current NPPF, unlike the preceding NPPF, requires that a sufficient number of sites are planned for and allocated at the plan making stage in order to meet the minimum requirements of paragraph 23.
Right.
That was not a requirement of the 2012 NPPF.
So just for my notes, so that Mrs. Richards can check for me while we continue this cross-examination, I think it's your evidence, as I've understood your answer, that since July of last year, the framework has required the identification of enough sites to meet the full requirement, whereas previously it didn't. Is that your evidence?
Sorry, the 2018 framework brought this in.
2018, since 2018?
And as I say, we don't know, well, I can't recall the evidence before Mr. Bohr. It may have been the council's case that there was, and I expect it was, that there was a sufficient supply over the planned period to meet the minimum house requirement. We now know that's not the case.
Well, Inspector Moore obviously wasn't persuaded, which is why he attached the flexibility allowance. So Mrs. Richards has got a point. She can explore it for me, and we'll see whether I ask you questions or deal with it in submission. But there we go. Now, going back to the question which prompted that exchange, I think it's your evidence that the flexibility allowance won't work in the sense that, assuming the shortfall is that which Mrs. Richards has identified, your evidence is, well, good luck, but the flexibility allowance isn't going to deliver the amount of housing that you need. I think that's your evidence, isn't it?
Precisely so.
Good. Well, then we can all agree this, can't we? That if one is to voice an opinion as an expert, one needs to have assessed the primary facts to determine whether that opinion is soundly based.
I mean, I would agree, but we heard from Mrs. Richard precisely the opposite proposition without any evidential basis, and I've just rebutted this new position of Mrs. Richard and not been afforded the opportunity to introduce that evidential basis because it only arose on the stand, an hour ago?
Yes, well, that was through your own counsel, so I'm not going to let you off that easily. Here's the question. You take the view, and it was put to Mrs. Richards, that the flexibility allowance will not secure the additional housing that's necessary to bridge the shortfall that was explored with her. That's right, yes?
Sorry, that even if the council's trajectory is accepted, that's my position.
Now, all
yes.
I want to know is this, and it's a simple yes or no. Have you examined the actual delivery of housing reliant upon or rather consequent upon, I beg your pardon, consequent upon the flexibility allowance, that is locally and on appeal? I think the answer to my question is you haven't.
Well, apart from within my proof of evidence identified that on greenfield sites outside of settlement boundaries, which will include sites which have arisen from these policies, 859 have accrued, and even though that's happened, the council still remains substantially short.
Well,
and that's since the operation of the policies since 2017, so that's 5 years, have produced an outstanding supply of 859, which haven't been delivered. So, yeah.
Have you taken account of Youngwood Lane at Nailsea and come to that figure? Doubt it.
Oh, well, let's have a look.
Yeah. Let's have a look. What page are we going to go to?
Page 21. Yes, I have. The final entry in the footnote 17.
Well, you said the majority of Youngwood Lane, landlord for Youngwood Lane.
Yeah, some of it I think was within the settlement boundary.
Well, yes, some of it was, but it was a big lump of housing, wasn't it, within the settlement boundary?
Yes, that's why I've said the majority.
Very good. And what we have there, I think, trying to find your footnote in the text there. Yes.
Sorry, can you just clarify exactly what you're looking at there?
I'm looking at paragraph 517, sir, on page 21 of Mr. Tiley's proof. And it's the first bullet point of 517. And I think the point I'd like to put to you, Mr. Tiley, is this, that it's right, isn't it, that with 859 homes on unallocated greenfield sites outside of settlement boundaries is not a comprehensive record of development permitted under the flexibility allowance. It's right, isn't it?
Yeah, entirely true, because it's only the sites which the council rely upon within their deliverable supply.
That's fair enough. Good. Okay, so if one asks the question, is there an evidential basis one way or the other? I hope I'm being fair by saying one way or the other, which indicates the flexibility allowance won't work. The answer is no.
No, I maintain that there is evidence. even if the council's trajectory is accepted, you need 1,500 homes to gain planning permission and be delivered within 4 years. That's just by any measure never going to happen.
Shall we explore that? Because you see, in order to get more homes, one needs a bunch of planning permissions, agreed?
Yes.
And in order to get planning permissions, we need developers to come forward with sites.
Correct.
So we know that there are 9 service villages, a bunch of large towns and Weston-super-Mare, all of which have settlement boundaries, which the core strategy indicates are locations where developers can apply for planning permission if they want to. Yes?
Correct.
So all developers have got to do, if they want more housing, is ask themselves the question, where does the development plan say we can build, and apply for planning permission on sites of the requisite size at those places.
Correct.
Yeah.
But you're relying upon developers having options on sites which accord with those policies of a sufficient scale and sufficiently well negotiated in advance through the pre-planning process to facilitate that. There's no evidence of that. And even if there was a wealth of planning applications to be submitted tomorrow that accorded with those policies, if we think it takes typically from the submission of an application, on average, 4 years until the first completion is achieved, according to start to finish. Obviously, some will deliver in advance and some will deliver afterwards. But so let's say, because it's an average, half will deliver sooner, half will deliver later. So you'll need planning permission for 3,000 homes, all of which are ready to go to be approved now in order to address that deficit. It just seems...
Well, I was talking about 1,500, so let's just stick with 1,500. Because you see, all I'm putting to you is this. Oh, fair enough. Oh, I see. Okay. Well, let's look at it like this, shall we? Insofar as there may be a need to boost the delivery of housing, the development plan provides a facility for developers to use, and it's up to them to make policy compliant applications. And if they do, we can expect, can't we, both the supply of land for housing and the delivery of housing to increase.
Sorry, I think we're talking entirely cross purposes. You seem to be suggesting that the development plan policies, well, firstly, your proposition seemed to be that there's one developer out there who controls all the development potential parcels in the country. Obviously, there's a lot of disparate developers, each of which may or may not have options on different sites, which may or may not comply with these policies. If they do, I would imagine most of them will have brought them forward already.
Well, I put the point to you. It's one I can make submissions
so
on.
Maybe phrase the question again so that I can understand.
No. I think it's... You see, all I'm trying to do, Mr. Tide, is we often find as a local planning authority, we're told how useless we are. Sometimes it's just useful to look at it from the other end of the telescope, but I'm going to move on. Just look at the last point under paragraph 51, which is, and how much of it being need, the development will meet. Now, what's your assessment of the shortfall?
I think am I 2,990 5-year land supply shortfall? I think
How much?
From memory.
Just say that again, would you?
I think it's 2,990 from memory.
Just give me a second.
Yeah.
Yeah. All right. Well, if one is to ask the question how much of it the development will meet, answer 2%.
That's correct.
Yeah.
But it must, the contribution that a site makes to addressing a shortfall, I mean, the greater the shortfall, if you were to use the logic suggested by that question, the greater the shortfall, the less weight you'd afford to developments of the same scale, because they'd make a smaller contribution to meeting the shortfall.
Well,
that just, to me, doesn't seem to stand up to logical scrutiny.
well, I think it's probably a bit more nuanced than that. If one had a significant shortfall and a large site were to come forward that could meet a big chunk of that shortfall, one can see that it might be something that would weigh in the balance, that a big chunk of that shortfall would be met. If a development only meets a very small part of the shortfall, but would have a significant impact on overall sustainability in a negative sense, you can see there that the fact that development would only meet a small part of that shortfall would probably be quite important as a contra-indicator to the grant of planning permission. Wouldn't you agree?
No, I don't. But let's work on the hypothetical basis that the council had a shortfall of 60 homes. You would, in that circumstance where the council had a very minimal shortfall, that proposition would be to suggest that the appeal scheme would be afforded much greater weight than it will be in the current circumstance where there's a shortfall of almost 3,000 homes. That just can't be right, I would suggest.
Well, I think that's probably getting to matters of submission. Last topic, and it's very brief, affordable housing. I think you do know the judgment in Kingsley and West Norfolk Borough Council versus Secretary of State for Communities, Local Government and Elm Park Holdings reasonably well, because we talked about it before, haven't we?
I'm not familiar with that judgment. We may have, but I'm guessing it was 6 years ago when we last met.
Was it really?
I think it was 6 years. It was of that order, and I certainly can't recall it, and it's not a judgment that
Well,
I'm familiar with.
I'm not going to go there. I can make submissions. If one is thinking about affordable housing, just taking a more general approach then, the framework and the guidance do not require, do they, a local planning authority to meet the full need for affordable housing. What they have to do is meet a proportion of that need. That is their obligation.
Well, I agree with the first proposition. National policy does not require affordable housing needs to be met in full. But national policy doesn't require a proportion to be met. National policy requires one's judgment to be exercised to make an appropriate contribution towards meeting that need. Now,
Sure.
that's in terms of requirement and planning, as in plan making, but in terms of the weight you afford to the provision of the housing, that must be viewed in the context of the need for affordable housing. That's the material consideration relevant at that stage.
I agree. And when one asks the question, what is the appropriate contribution that a site which is developed for housing should make towards affordable housing, the answer is to be found in policy CS16.
Correct.
And it's no part of the appellant's case at this inquiry, and if it is, you'll take me to it. I've probably not read it properly, in which case I shall apologise profusely, but I don't think it's the appellant's case that policy CS16 is out of date.
Again, that's, well, I mean, it is out of date because there's no 5-year land supply, so if it's a most important policy, it is by fact. But I have, it's certainly beyond the scope of my evidence.
Then I can ask Mr. Wakefield about it. And if he says it is, we shall explore where he says that. Good. In that case, Mr. Tiley, thank you very much.
Thank you, Mr. Leader.
Thank you. And a short break.
If you want, sir.
Yeah, if it's yeah, yep, that's fine. Yep.
It seemed to be suggested that one of the reasons why the council's projections as to why there hasn't been delivery in accordance with what they've told previous inspectors is the fault of the development industry. And let's look at it from the other side of the telescope. Tell me, what evidence, if any, have we got before this inquiry that there is land banking going on from the development industry in this local authority?
Well, no evidence whatsoever, and to my mind, land banking isn't something which exists. Developers, once they are able to bring forward a site and have invested in that site, make a financial loss from holding onto the site and land banking. It's entirely, there's a fiscal disincentive to the proposition of land banking. It just doesn't exist. Any sites that are being held back will be being held back for technical reasons or because of being stuck in the planning process, in my experience at least.
Thank you. The next question for you is, it was being suggested that policy, the flexible approach and the ability of the flexible approach to achieve and remedy housing. Tell me, we were told about 2 sites in today that achieved that, one for 25 and one for 50 units. So we've been told about 75 units that have been delivered along this flexible approach. Are you aware of any other sites that have been delivered along this flexible approach?
No, beyond Mr. Leader directing me to Youngwood Lane, as referenced in my footnote.
That was amongst the two. That was amongst the two, as I understood it.
No, I'm not.
So is there any evidence at all before this inquiry that there's been anything more than 75 units?
Not as far as I'm aware.
That's not correct. He took us to his own evidence, but yeah, that is.
No. My evidence shows that 859 homes have been granted on greenfield sites outside of settlement boundaries, including the majority which have been granted on appeal, notwithstanding the council's presumed opinion that they didn't accord with those policies.
So sorry, I must have misunderstood your evidence.
Is there evidence before this inquiry, or to what extent is there evidence before this inquiry, that there is available alternative sites on the edge of settlement boundaries that would accord with this flexible approach? Again,
I think I alluded to that. There is no evidence of any such sites.
Thank you. And finally, paragraph 69 of the framework, if you would, please. Yeah. So you'll recall we were talking about when we're looking at the Hallam land judgment, and one of the factors that the court says have regard for is the ability of the site to contribute to remedying the issue, or words to that effect. We saw Mrs. Richards said that she agreed that this was a medium-sized site. Your view on that?
Yep, I would agree.
To what extent, if at all, would a site such as the appeal proposal be able to make a contribution in a short and medium term to actually remedy a 5-year housing land supply shortfall?
Well, I mean, I don't represent this site per se in terms of its individual delivery prospects, but sites such as the appeal site are those which stand at least a prospect of being delivered within the 5-year period. If you get to much larger sites, their delivery timescales will be well beyond the 5-year period, whereas medium-sized sites such as this could well contribute within the 5 years.
Yeah, well, that's my point. If we were sat here and we were talking about a site for 2,000 units, what confidence would the inspector have that that would be the sort of site that actually, even though it would take half of the unmet need, what confidence would an inspector have that that sort of scale site is actually going to do anything?
I would suggest that you wouldn't have any. I don't think anybody would be suggesting that a scheme of 2,000 dwellings would contribute within 5 years.
Thank you. I've got no further questions.
Thank you.
Thank you. Okay. I've got no questions, but it is it's 3:10. I think we'll take a short break. We will be coming back. We will do the round table. Just bear in mind, we don't need to repeat everything that we've already discussed, but we'll go through and I'll come to one side and the other, and we'll work through that list. If there's any that you don't feel that you need to discuss, just tell me as we go through and we'll skip over them. Okay, so just literally sit at the table.
Accept.
Okay, if that's fine. And I'll direct my questions to the witnesses, but obviously you're not precluded from engaging. Okay, so we'll take a short break and we'll come back at 3:30. Okay, the inquiry is adjourned. It's 3:30, inquiries resumed. We're now in round table format. So I'll lead the discussion on which is basically the Scotch schedule of disputed sites. What I'm going to do, I'm going to work through the list. I'm going to come to one side and then the other. For the category A sites, I'm going to come to the appellant first, and then for the category B sites, I'm going to then come to the council first. So yeah, well, it's simply, if you've got the Scotch schedule to hand, it'd be worthwhile to have to hand perhaps the paragraph 68007 of the PPG, and what it says may include such evidence that could be clear evidence. So the question is going to be fairly consistent as I go through, is what is the clear evidence? So it's not an exhaustive list, as we know, but it is what it is. And bear in mind what we've discussed earlier today, and the points that have been made, and the appeal decisions that we've been taken to as well. Okay, so
It's my practice not to play much of a role in this thing.
Yeah.
As far as I'm concerned, Mrs. Richards is the expert.
Yep.
And unless I've got something really pressing to say, I'm going to be quiet.
yep, that's fair enough. Yep. Yep. All right. Good. Okay then. So stay on with the schedule then. Category A sites, the small permitted sites. Does anybody want to say any more about why or why not the council should have adopted a lapse rate?
So I think it's all been largely covered in evidence in chief and cross-examination, so I'm happy to leave it.
Yeah.
Yeah, I agree. I've said everything that we need to.
You need to add anything else? I mean, I've not got any questions based on what I've heard. Okay. So then the large sites with detailed planning permission, clear evidence then that homes will not be delivered is what I'm looking for there. Come to the appellant on them. So 2 to 6 Bay Road. This issue about bed spaces and whether the council should account for them or not. So do you want to?
Thank you, sir. Paragraph 35 of the PPG says local planning authorities will need to count housing provided for older people, including residential institutions in use class C2, as part of their housing land supply. On this site, there's been a loss of the equivalent of 17 homes arising from residential bed spaces, which the PPG says you will need to take account of. The council haven't, and that's the entirety of the
So you say equivalent of 17 homes. What's the council's response?
Yeah, as I've set out in the schedule, I disagree. The council, I acknowledge that paragraph, have commissioned an older people's specialist housing needs survey to establish a baseline.
Do you in principle say that you should account for the loss of any of those bed spaces?
No, on the basis that we don't have the baseline data and that the council haven't sought to count any gains of bed spaces in care homes either.
So there's no gains in there?
There's no sites in there where we're recording a gain of any care home accommodation. All of the units that we've recorded are self-contained units of accommodation. We're counting the delivery of those against the housing requirement of 20,985. So as no gains of care home bed spaces are assessed, we've taken it that we shouldn't do the losses until that baseline has been established by that piece of work.
So and then your ratio then that you've used, what is it?
It's taken directly from the PPG, sir.
Yeah. Okay. Is there any more we can say on that?
I mean...
Do we need... No, if you don't feel there is, I'm not saying you need to, but
all right.
do we want to...
I'm happy.
I'm clear of where you're coming from and clear of where you are. Okay, so the council aren't accounting for losses of any. Is that so? Any specialist housing that would be?
Yes, that's correct.
Okay, yeah. But you're also not accounting for any gains, just to be clear.
Yes.
Okay, 69 to 71, Locking Road, you've got the difference of a dwelling.
So, yeah, but this again is there is a loss of a dwelling
Yeah,
as part of the scheme, which the council haven't accounted for.
is there a loss of a dwelling?
So, as I put out in the schedule, there is a bungalow, as it's referred to in the planning application, but that's a vacant, uninhabitable unit. It's not paying council tax. It doesn't exist for the purposes of someone living in it. So it's not been treated as the loss of a dwelling unit. The difference between the gross and net figures, we go through all of these sites individually, and on that particular case, we're not recording it as a loss, as I say, because it's a vacant, uninhabitable unit.
Vacant, but it is still a dwelling.
Its last lawful use was as a dwelling, that's correct.
Right.
What's uninhabitable about it?
It's vacant, derelict.
Derelict.
Yes.
But it has nevertheless been lost at some point, and it's whether at the point it became uninhabitable it should have been lost, in which case there would need to be an allowance in the council's assessment for the loss of such sites, or, as every other LPA does, you record that loss at the point it's demolished or converted to another use, as I suggest you should. But in either event, there would have to be a net loss somewhere, sir.
Sir, I'm not sure I'm using your time well arguing about one dwelling, but if it's not habitable, then it's not a dwelling, and there's no net loss to record.
Okay. All right, I'm going to take both sides' points. I don't want to debate that at length, given the implications.
The same principle applies to the next site on the schedule, I think is fair to say.
Yeah, again, the planning permission for a loss of a C3 unit, which will be lost.
Okay. So we can move on to page 3. Leonard Elms is at exactly the same point as the previous site.
Yes.
Golden Acres, this concerns the Bay State. Do you want to tell me why this one shouldn't be included?
So every appeal decision of which I'm aware, of which there were probably approaching 30, has concluded that sites which post-date the Bay State, including sites which unallocated sites which benefited from a resolution to grant to the Bay State, as this one does, should not be included. Particular examples of that are paragraph 67 of CDG 39 and paragraph 62 of CDG 40, sir. So it's inconsistent with the finding of every inspector of all time, as far as I'm aware.
What does the council say to that?
Nothing beyond the evidence I gave this morning that, as I said, this site benefited from that resolution to grant consent. It wasn't just the planning application that was in, it was deemed to be suitable in principle and resolved to grant. So I've got nothing to add on that one.
Right. Do you take the point that it's not that I'm saying, but Mr. Tiley's saying that it's inconsistent with those?
I accept that. I was taken to appeal decisions, yes, where that was found to be. The further point I made this morning, given the passage of time, we have also taken out large sites which have lapsed during the intervening period. So I would dispute the accusation that we've tried to add supply in at the front end and not remove supply, which has since lapsed. But
this one was already included in the supply.
we took a cut at April and we included, it's this one and one other, I think, which are disputed, where there was a resolution to grant rather than the actual decision notice being issued. And that happened a month later. Both sites, incidentally, were full consents and they're both under construction now.
Right. Okay. Obviously got what's written in front of me. Do you want to say any more in response?
No, I mean, there's such a lengthy and consistent finding of inspectors that I can't see any reason to depart from that well-established principle of inspectors in their interpretation of national policy, sir.
So may I just offer you this thought now, should be quiet. The question is the site deliverable or not? And if you've got a resolution to grant followed by a planning permission, then viewing the evidence in the round, it plainly is. Whether it's category A or not is immaterial.
Sorry.
That's not the point that we're debating.
Well, in that case, I'll be quiet.
Okay. Okay. Plumtree Farm.
Thank you, sir. This is a site which gained reserve matters approval in 2008. I can't see, well, on the ground there's no signs that a technical commencement was achieved, but the council suggests that it was. But even, well, if that wasn't achieved, then planning permission's expired and this site should never have been included to start with. But even if a technical commencement was achieved, there's been no progress in 14 years, which I would suggest provides clear evidence that completions, in the absence of any evidence that circumstances have changed, I'd suggest that provides clear evidence that completions won't come forward on this site, sir.
Okay. So what is the technical commencement? Is it?
It's the access, and there's correspondence on the planning file. I thought that was available on the public planning file, but either way, to confirm that the access has been implemented, and therefore the planning application will not lapse. This site in itself is a slight anomaly. It's recorded on the large site schedule, despite being for only 8 units. It is therefore minor development. It's recorded on this schedule by virtue of the fact it was a residual parcel of a larger allocation.
Should it be on this schedule then?
So it is in that the allocated area was carried forward into the development plan. If it were anywhere else and not within the red line of a previous allocation, it would have been on this small site schedule.
Yeah. Okay. So what's the clear evidence that it will be delivered then, if it's all that time ago and access is put in and nothing
So
has
you
happened
don't need
since?
clear evidence for this site because it's a category A site. I need clear evidence that it won't.
Sorry, the clear evidence that it won't then?
So my clear evidence that it won't is that nothing's happened for 14 years and there's no signs of development forthcoming.
Yeah. Okay. I suppose my question is almost what's your response to that?
Yep, so we write to the developers each year and are consistently advised for the last, we didn't undertake the full exercise last year due to COVID, but have been advised that there is their intent to deliver within 5 years. So as I say, being a minor development, that's why it's therefore included.
So you wrote to them when, sorry?
We write to the developers of all of the large sites each year with a pro forma and ask them to complete it. Are there any constraints that they need to overcome?
Yeah.
What progress are they making? That kind of thing. Bit of a developer questionnaire, if you like. And the last response we had from them was, as I say, we didn't do that last year, so 21. We wrote to them in 2020, and they advised their intent to complete within 5 years. So on that basis, we've still included it within the schedule as a minor development. It's not for the small sites, no, we don't publish any of that information.
Sir, if I might pick up on one point as well, this is a particular example of a small site not being implemented within 5 years, indeed not being implemented within 14 years, which further supports the necessity for a small site non-implementation rate going back to our previous discussion, sir.
Okay.
Would you like us to put that record of correspondence in? Well, it is fair. It's either
Well,
there or it's not.
Well, to be fair, I think I suppose it's no surprise that we're discussing these sites, and the requirement is for clear evidence on both sides. I'd say, why has it not been put in up until now?
This site hasn't been disputed in any of the previous 3 inquiries where we've debated this.
So we'll get to a position as we go through this schedule that there may well be others correspondences that you wish to put in, presumably.
Well, so yes, on this basis, Mrs. Richards is saying we've written to people and they've given us a response. Well, it's either true or it's false. You will attach such weight to the response as you see fit, but if it's being suggested we haven't had that response, then I think it's only fair we should say, well, as a matter of fact, we have. What weight you give it is another matter altogether.
Right.
But it seems to me that it's only fair to Mrs. Richards if it's being suggested she hasn't got this response, and it doesn't contain a certain statement, we should be able to correct that.
So just to clarify what the response is it a questionnaire and then they've ticked a box that they say simply we'll deliver
Yes, so
this
there are
by
some
X date?
examples of those for the larger sites within my appendix NR4.
Yeah.
There are copies of some of those for the larger sites where in those cases they would usually set out their trajectory. We'll build 25 this year, 30 the following year, etc. We sent this, again, because it's on the large site schedule. For the sites of 5 or more, we tend to write to them, see what's happening with them. So I haven't put that one in. As I say, that wasn't disputed in any of the other ones. And we didn't undertake it for any sites of less than 10 last year, which is why we don't have a 2021 record for that one. It's assumed, given its status, that it is capable of delivery within 5 years and hasn't been challenged
And
to date.
on this one, is it simply that they've ticked that box and said that we will deliver?
Yes,
Right.
it will be for a site of that size.
So, okay. Just given the evidence, she's told me I've got no, reason to doubt what she say is true.
I would agree that because this is a Category A site, it falls on me to provide clear evidence. Given what Mrs. Richards has just said, it appears that circumstances may change, and I'm happy to concede the 8 dwellings from that site, sir.
Land north of Youngwood Lane.
Yes, so this is the first of these sites with
Yeah.
outline planning permission now.
This is the Category B sites with outline planning permission for major development. So, do you want to elaborate on any of the clear evidence?
Yeah, so it's summarised in the council's position
I
column.
suppose what I would just say is, have you got any indication as to when the reserved matters would be submitted?
Again, this is email correspondence dated the 3rd of March, and again, I don't believe it's in front of this inquiry, but was put forward during the session at the Farley Fields inquiry. So that came forward whilst we were debating the session, that their reserve matters for phase 2 is being prepared. So to give this site some context, it's for 450 dwellings in total. The first phase of which is 168 dwellings, has full consent and is being built out. And this is the phase 2 element, which is 282 dwellings. And I've forecast 200 of them within the 5-year supply, and then the residual 82 beyond the 5-year supply period. As I say, there's an email confirmed, which was an inquiry document in the Farley Fields case, to say that their planning application for reserve matters for phase 2 is being prepared by Taylor Wimpey.
Did it say when that was likely to be submitted?
I don't have a copy of it with me. It was more along the lines of imminently than a date.
Right. Along the lines of what, sorry?
That it was being prepared for submission imminently rather than giving a
Imminently,
date.
Right. Okay. Again, obviously I've not got the email. Do you want to comment?
Yeah, well, thank you, sir. The council's evidence in the Scott schedule appears to rely on 2 propositions. The first is that it's programmed to follow the build-out phase 1 and at a peak of 100 dwellings per annum. And the second is what was suggested in this email, namely that a reserve matters application is being prepared. The first proposition is based on mere assertion, which Mrs. Richards accepted in cross-examination wasn't sufficient. There's no evidential basis for that, seemingly. The second proposition, sir, is based on an email which is not before us. So the content is unknown. There's no written agreement before us which we can afford any weight in accordance with the Secretary of State and State plea. There's no written agreement before us that we can equivalent to the examples in the PPG. And as I say, the content is entirely unknown for us to afford any weight to that. In any event, the supposed proposition that a reserve matters is being prepared provides no evidence that completions will be achieved, which is the requirement of the framework. But even if, notwithstanding all of that, you, sir, were to consider that in principle this provided clear evidence, the first proposition is that the Phase 2 scheme will follow Phase 1, but the Council's trajectory assumes that they deliver at the same time. So the evidence of the Council doesn't even support their trajectory. The second proposition, that it, without any evidential basis, is that it will peak at 100 dwellings per annum, and yet the Council assume it will deliver 100 dwellings per annum from year 1. So again, it's not supported by the evidence of the Council. And the final point I'd make, sir, is this is a single development outlet. On Phase 1, the Council trajectory is that it will deliver 50 dwellings per annum, which is broadly what you'd expect from a single outlet, between 40 and 50. The Council then assume in year 3 that it will deliver 168 from a single outlet, and in the final year, 100 dwellings. It's just unrealistic, the Council's trajectory, to my mind, sir.
Okay.
If Mrs. Richards has written in the schedule, as she has, that she has received information that Taylor Wimpey are preparing reserved matters application, and that information has come via an email, which she records, then you are entitled to say to yourself, can I trust Mrs. Richards? Do I believe what she says here? And does the email say what she says? And if you conclude that Mrs. Richards is a truthful witness, trying to help the inquiry, and that what is written here is true, you're entirely able to take that into account. And furthermore, knowing that it is a reserved matters application, when it is indicated that the National House Builder, such as Taylor Wimpey, thinks that they will be able to turn that into 100 houses in 2024, 25, and 25, 26, that is hardly unrealistic or fanciful. So, sir, given that what is written here says what it says, given the appellant didn't come back and say, well, could we have a look at that email, please? I think you can take this at face value, look at the trajectory, and conclude that for a major house builder, this looks realistic.
Sir, if I might come back on a few points there. I think Mr. Garvey's got a point as well. Sorry, Killian, do you want to go first?
Yeah, can I deal with the procedural points there about evidence? We got these comments back from the Council on Friday, so the first mention of this email was Friday. That was already way, way too late to be bringing in new evidence, but we didn't challenge it. We thought, we'll let them put it in and we'll address it, sir. What I think is far too late is for the Council to be putting in additional evidence to support their case. They had the opportunity to provide the clear evidence. It's an inquiry, so naturally it's a forensic exercise. We can't be dealing with late evidence and then having to recall Mr. Tiley because it might or might not change his view. I think it's fair, sir, that we examine it based on the evidence that's been submitted to date.
Yep.
That email's not before you.
Yep. Well, I think that that's what Mr. Leader was saying, isn't it?
Absolutely.
That's what I took from what he was saying, but I think it's okay for you to, and welcome to just clarify what it is that we're doing as we go through.
Yeah. I mean, if this was a criminal trial, we'd trace the evidence all the way back and look for the knife with the blood on it, but actually, we've got the statement here, which is as clear as a bell. Do you trust Mrs. Richards or don't you?
Sir, if I might just come back on that. I often give evidence at these appeals, and where people rely upon, where councillors rely upon emails, they might often say a reserved matter's under preparation, and I trust Mrs. Richards that that's the case, but it might also then go on to say, however, we won't be delivering until X, we will deliver at a rate of Y, all of which we can't tell because we don't have the written correspondence.
No, we don't have it. What we have is what's here.
That is, so we prepared this schedule on Thursday and Friday of last week. I think the email is in the Farley Fields evidence as part of my rebuttal. Now I know you've read my Farley Fields evidence because indeed extracts of it are included in, someone in your team has, they're in core document section J. There's statements of common ground and other material from that site's inquiry. Again, this was put into here, the reference to the email. I filled out that column on Friday. That's all I can say.
And then this statement probably runs for any subsequent discussion of this kind. I would expect my witness to draw to your attention anything contained in any correspondence which tends to undermine the case she's advancing here. So, Mrs. Richards, if there is anything in the email that would qualify the deliverability of this site? Will you tell us now, please?
As I've said, I haven't got the email
No, I know
physically
that,
with me.
but is there anything in it which would tend to indicate that this impression you give of deliverability is exaggerated? Because if it is,
No.
tell us.
No, there isn't.
Thank you.
Okay. So the point about there being a single outlet and achieving these levels of development, did you want to respond to that point?
Only to say that I appreciate a lot of the developers are using these start to finish kind of average build rates for these sites. We tend to look at these sites individually, look at other local sites which are coming forward and try and pitch them at similar rates, supported by where we can get a response, that of the developer.
Okay, so this figure is based upon a single outlet, is it?
Yes.
And is it based upon the phases following on from each other or running concurrently?
There is overlap, Mr. Tiley's right. So this just gives you the extracts from the trajectory of the sites that are in dispute or in agreement with the phase one, and that does run to the 2024-25 year.
Sir, if I can just come back on
Yeah.
a few points. Firstly, I haven't seen the Farley Fields evidence. I have seen the Farley Fields statement of common ground, but not the evidence. So I haven't seen this email. But even, as I said, even if you were to accept something that's not before you and therefore cannot, by definition to my mind, provide clear evidence, the assertions of the council don't support their own trajectory, and the trajectory is patently unrealistic for a single development outlet. So regardless of whether or not that email is to be taken into account, my position would remain unchanged.
Well, the email's not being submitted and I've not got it, so I'm not going to be taking it into account, but I'm going to take into account that what it says in this box. Okay. Anything else about that site?
No.
Page 5, land to the west of M5 and east of Trenchard Road. So again, indication as to when the reserve matters might be expected.
So a pre-application submission was put in a month or so ago by Pegasus on behalf of David Barrett Wilson Homes, which is clear evidence of intent and firm progress towards submission of a reserve matters application. Given that's so recent, again, it's a difficult balance. We can't keep chasing the developers for information weekly. So that pre-application submission for the reserve matters, in my opinion, is clear evidence of intent.
And did that say that they would be starting at this particular time and specify how much they would deliver each year?
It's so recent as at a few weeks ago, I haven't been through it myself to look for detailed delivery rates in it, no.
Right. So what were these rates informed by then?
Again, these rates were based on the initial intention in the outline application. There's references to that on page 66 of my appendix NR4. So we took those from the outline. And 25 per annum for the last 3 years of the 5-year period to allow time at the beginning for the reserve matters to be secured.
Okay, and the lead-in time, does that seem reasonable given that we've not got the reserved matters yet?
For a site of this size, again, given the passage of time, we are now nearly a year on from this trajectory being prepared. The outline consent was granted in November 2020. So factoring in those 2 years for the kind of marketing, the planning consultant to prepare the reserve matters, I consider 2 years to be a reasonable period for that.
Okay. Mr. Tiley?
Once again, sir, similarly, sir, as I understand it, the council are relying upon the submission of a pre-application, a request for pre-application advice. Now, clearly, we don't know the outcomes of that. So again, there's nothing to afford weight. But even on the council's case, this provides a clear evidence of a firm interest. It provides no clear evidence that completions will be achieved as required by the framework. And indeed, sir, this is an outline planning permission without a reserved matters application where there is no written agreement, exactly the sort of site which the Secretary of State found to not be deliverable in the state plea appeal decision, as we went through earlier on with Mrs. Richards in cross-examination. Furthermore, sir, the lead-in time is unrealistic because this site, well, it's unrealistic in any event. Start to finish suggests that it would take roughly 2 years lead-in from the grant of a reserved matters until the first completion. But on this site, there's a requirement for an extensive acoustic bund all the way along the M5 to protect these dwellings from the motorway noise. With that significant piece of infrastructure up front, the trajectory of the council, to my mind at least, is unrealistic, sir.
Do you want to come back on that?
No, I've got nothing to add, sir.
Page 6, Oxford Plasma Technology. So you've got an existing business that needs to relocate. The site that they're relocating to, has that got planning permission?
It's got planning permission and it's being built. It's due to complete. There's a press release and details of which set out in my evidence within 3 months of when that was written. So, as I say, they did have planning permission. Outline consent for this site recently expired as those relocation plans were delayed. Still benefits from development plan allocation status, but they are relocating. The premises is being built.
So do we know when the site will be available then?
Again, within 3 months. That press release, I believe, was dated in January. There's a copy of it in my evidence.
Okay. And then the progress towards a fresh application for this site then, what?
There's no submission to date that I'm aware of yet.
Right. Has anybody, has there been anything to say that they do intend to somebody is connected to this site and does intend to put forward a proposal?
So Red Row Homes previously secured the past consent. They have an option on the site. And I'm not aware that status has changed.
Right. But until recently then, has anybody discussed the prospect of bringing forward an application on this site?
Not personally with me. I've been sat in appeals for the last 3 months, but no, not that I'm aware of.
Not that you're aware of. Okay. Mr. Tiley?
Well, the starting point is that outline planning permission has expired, which from the outset suggests that there are problems with this site. The second point is that the site remains in use now and is therefore not available for development now and therefore does not meet the requirements of the NPPF definition of a deliverable site as set out in the Wayne Holmes judgment, paragraph 34, Roman numeral 2. The third is that the evidence of the council is simply that the existing business has secure consent and is delivering a new site, a relocation site. Now that again provides no clear evidence that completions will be achieved on this site and certainly nothing akin to the examples of the PPG. And the final point is on the realistic prospect. Prior to the development of this site, sir, the site in Bristol, the relocation site, needs to be completed. The company need to relocate. A fresh planning application needs to be received, determined, hopefully favourably on Oxford Plasma site. The extensive built form needs to be demolished. very probably remediation needs to be undertaken. I just cannot see any realistic prospect of this delivering within 4 years, given all of the pre-completion works that are necessary on a site such as this, sir.
Do you want to add anything?
I've got nothing to add beyond what's in my evidence now. I'd just be repeating myself.
All right. Land south of Station Road. Reserved matters again. Is there any inclination as to when that might be?
Revised planning applications actually being prepared for 25 dwellings as opposed to the 13 which had consent at the time of drawing up this trajectory. The site's allocated for residential development in the Congsbury Neighbourhood Development Plan. As part of that new planning application, it was submitted just before Christmas. It contained planning I won't read it out. It lists in that box there for you all of the assessments that have been prepared and promoted to support that.
Mr. Tyler, do you want to?
So the evidence of the council, sir, appears to rely upon a statement submitted in support of a planning application that was approved in 2019. That's clearly out of date, sir, and therefore does not meet the requirements of the PPG 007. And similarly, the findings of the Sturry appeal decision. In any event, the evidence then goes on to rely upon the submission of a revised planning application. Now, that immediately indicates that the existing planning application will not be implemented, and we don't know how the council will approach the revised planning application. We have no evidence to say that they will find that acceptable. And therefore, sir, there is no, once again, no clear evidence of completions. The completions will be achieved at all, let alone by any timescale. And there's no examples, no evidence akin to the examples of the PPG. And once again, sir, if you were to apply the approach of the Secretary of State, this is an outline planning permission with no reserved matters application, and there is no there's no written agreement between the parties. So it should not be considered deliverable according to the Secretary of State in the State plea decision.
Okay. Do you want to say anything? Response. Page 7, west of Wolvershill Road.
This is a point of principle, I think, exactly the same as the Golden Acres fruit farm that we talked about and the Bay State.
So nothing to add to the discussion we've already had?
Not beyond, again, this site is now already under construction, but no, we've covered the matters.
It's under construction?
Yeah.
Mr. Tiley?
Well, once again, it's a site which post-dates the Bay State and therefore responds to a different need. And because the council haven't excluded the completions which had occurred prior to this site gaining planning permission, which were no longer deliverable, you provide for an inequitable assessment. The same points as were previously rehearsed or have been rehearsed in evidence.
Have you got a figure for those completions that you just
No, I don't think the council have published any assessment of the number of completions that would have to drop out if sites which subsequently became available were to be included.
Do we know?
We haven't, no. This site, we say, was legitimately included at the base date of April, as I put in there. It had a resolution to approve and secured its consent. The decision was issued in May.
Bleeden Quarry. So is this site, has it been vacated? Is it available?
The quarry operator has vacated the site, yes.
Okay. So you say it's for sale. Is there a developer attached to it? Has there been any discussion with anybody about bringing it forward in the form of a planning application?
No, my correspondence was with the planning consultant. As I put there, confirms that the site was for sale. A copy of that email correspondence is in my evidence.
Yeah, and I thought, So no clear evidence that completion, where did the figures come from for
I believe in this case they were taken from the planning application, the outline application submission.
Mr. Tiley?
Once again, the evidence comprises just that the operator has vacated the site and it's for sale. That, again, provides no clear evidence that completions will be achieved within 5 years. And once again, if you're to follow the approach of the Secretary of State, outline planning permission, no RM application, no written agreement, so not deliverable. And the final point on this one is that the Council have included 48 in the supply when actually there was an a permission for 48 homes which expired, and the current outline planning application is only for 42 in any event. So the supply would have to be reduced by 6, even if you, contrary to my position and that of the Secretary of State, consider there to be clear evidence.
John, should it be 42?
It should now be 42, yes.
Okay. Page 8, Millcross. So it's allocated site. This is one of those that we talked about, that's subject to that clause in the policy about flood risk assessment and sequential intersection tests, isn't it?
Yes, yeah.
Okay. So those particular issues, is there any knowledge that they've been progressed for this particular site?
Yep, so again, we were told, and a copy of that email is in my evidence, that the planning application, which will include the sequential and exceptions test information, is being prepared to be submitted in summer of this year. And then they go beyond that to set out their anticipated build programme.
Okay. So the evidence is being prepared. They've provided you with a build programme, and that's what's informed these figures?
Yes, that trajectory was provided by the head of land and business at Alliance Homes, the affordable housing provider.
Okay.
So they've already received grant funding for that site, secured from Homes
So it's
England.
got grant funding attached to it
Yes.
as well. Is there any conditions of the grant funding?
Not that I'm aware of or have been disclosed by Alliance, no.
Not that you're aware of. Okay, Mr. Tiley, do you want to say anything about this site?
Yeah, two brief points for Sir. Firstly, in accordance with the findings of your colleague at Western Business Park, this site needs to be subject to a sequential and exceptions test. Therefore, unless you're satisfied that it will pass both of those tests, you cannot conclude that this site is suitable now, and therefore you cannot conclude that it's deliverable now. So it's a matter of planning judgment for you, sir, as to whether you believe this site will pass those tests, is the first instance, and I can't see any evidence from the council that those tests will be passed. And the second is a more minor point, is that the developer is advertising this site for 60 rather than 67 homes on their website. So I would suggest the capacity has been overinflated, even if you consider you've got sufficient evidence that the sequential and exceptions tests will be passed. Sorry, sir, I should say, it's fairly obvious this is in an area at high risk of flooding, flood zone 3.
Do you want to respond?
No, I've got nothing to add, sir, beyond what's in the evidence.
Point about 60 as opposed to 67 dwellings.
The email correspondence, the site was allocated for that many, and the email correspondence is dated November of 2021, and at that point we were talking about 67. As I've said, they were drawing up various schemes and preparing their planning application, so it may be that as part of the detail
That's based on what
they've reduced
recently
to a
told you,
60.
is it? Yeah. Okay. All right. Let's comment about the point about flood risk assessment and sequential tests and what I can take from it.
Not beyond the points of principle we discussed this morning, that
Okay.
those sites were nonetheless allocated in the full knowledge of the Environment Agency.
Yeah.
I found sound.
Okay. All right. North of Churchill Avenue, Clevedon. the same, isn't it, this one, in terms of the sequential test and exceptions test, is that right?
Yes,
Yes.
that is one of the criteria for this one.
Council-owned site,
It is. This was first allocated in 2018 as part of the site allocations plan. It's owned by the council. The trajectory that you see there was provided to me by the Head of Development and Placemaking. This site is included within the council's short-term development programme, given its allocation status. That development programme has been endorsed by the council's executive committee, and there's more references to that in my evidence. So a consultation on these sites called Better Places, Homes and Jobs is a consultation on that development programme for a detailed development schedule for each of the sites to be considered and ratified by the council later this year. That consultation is still open, I should say, so there's no results of it that I can offer. It closes a week today, I think, the 20th of June.
thank you. Mr. Tiley, do you want...
Again, the primary issue is whether you consider you've got sufficient evidence to conclude this is a suitable site, given the fact it's in an area of high risk of flooding and the absence of a sequential and exceptions test. But additionally, sir, the council are relying upon a trajectory provided by the Head of Development and Placemaking, which is not before this inquiry, and therefore I just don't see how that can be afforded any weight. And so once again, we go back to the Secretary of State's approach. This is an outline planning permission. Sorry, it's not even an outline planning permission, is it? It's an allocation with no planning application and for which there's no written agreement of delivery, sir. So again, if you adopt the approach of the Secretary of State, sir, this site should not be considered deliverable.
Do you want to say anything else?
No, thank you.
Nope. Okay. Yeah. It's really hard to speak into the microphone but then juggle this A3 document, so I'll do my best without keep bashing the microphone. Okay, page 9. Northwest Nailsea. Is that how it's pronounced?
Yeah.
Yeah. So what's the council's evidence on this one?
So again, this is a site first identified in 2018 and allocated in the site allocations plan. This site hasn't been disputed at the two recent inquiries for, this wasn't in dispute in Moor Road, the case that we have the decision for, and nor was it challenged at the Farley Fields inquiry. Hardly surprising it was the same witness for both. Vistry Group are preparing the necessary surveys and technical reports to accompany a planning application. That was confirmed by the housing land supply witness in that case, Mr. Nick Patterson-Neild, who's a partner at Barton Wilmore. They're representing Vistry Homes.
Okay. So have you got any clear indication as to when a planning application may well be coming forward? And what form that might take? Outline?
We're expecting it to be outlined, and we're told that it's being prepared, and it will then come forward in phases, the first phase being 150. So this is a total site of 450 homes, and in the trajectory we're only accounting for 150 of it within the 5-year period.
Okay. But you don't know when you're expecting that application?
No, I don't have a date for that, sir.
Has there been a pre-app discussion on it?
There has been a pre-app on it. It was over a year or so ago.
Right. And the figures then that you've put in, where have they come from?
They were discussed at the time of the pre-application and considered, as we were always told upon the point of it being allocated and promoted, that this would come forward in 3 parts, hence why we've put the phase 1 at the beginning with the 50 and then the 100. So that's from the pre-application discussions.
Okay. Mr. Tiley?
Thank you, sir. The evidence of the council firstly stems from the submissions prepared on behalf of the applicant back in support of the site and policies plan in 2018. So the evidence, the origin of the evidence at least, is now, what, 5 years old and is therefore out of date. See the PPG and the Surrey appeal decision. That evidence, as accepted in the second paragraph of the council's case, the milestones necessary to achieve that trajectory have not been met. So if you turn to the Secretary of State's decision in Stapley, where milestones haven't been met, there is no longer clear evidence. So again, if you adopt the approach of the Secretary of State, this site wouldn't be deliverable. And now we have the latest evidence is that a planning application is being prepared which provides no evidence that completions will be achieved, and nothing akin to the examples of the PPG. And once again, if you were to apply the Stapley approach, we have an allocation with no planning application and no written evidence of deliverability, such that, once again, if you apply the same approach to the Secretary of State, this site would not be deliverable. Additionally, sir, this is a site of in excess of 400 homes, which, according to the start to finish report, would take on average 4 years from the submission of a planning application until the first completion. This site is also affected by the fact that high voltage cables need to be undergrounded prior to that development commencing. So even a 4-year lead in time, which would put it outside of the 5-year period, would be unrealistic to my mind.
Do you want to respond?
Only insofar as the pylon undergrounding, that work has commenced in the vicinity of the site, and just to reiterate that was agreed with the planning consultant for that site.
The undergrounding of the electricity is commenced, does it?
It has commenced, not specifically on this site, I don't believe, but just to the south of it, on the line.
Anything else on that site? No. South of Downside, allocated site owned by the council.
Yes, so rather than repeat myself, this is part of the same development programme as the Churchill Avenue Clevedon site.
When you say programme, what do you mean?
So the short-term development programme for council-owned land that's subject to consultation at the moment. So my comments on that site would cover this site.
Do you want to tell me a bit more about what that programme is?
Yeah, so it's referred to in my evidence. The council's development and placemaking team are responsible for bringing forward the development of council-owned land. This is one that was identified and allocated in 2018 for 23 houses. And that short-term development programme was drawn up by officers and then ratified at executive committee in 2021 about the options for how they bring forward these sites. And as I mentioned, the current round of consultation is called Better Homes and Jobs, and is looking at how these sites will be delivered. And the current round will then inform site-specific consultations later this year to inform planning applications being submitted.
So the council would submit those planning applications to itself? It's not.
Yes.
Okay.
So on sites where there is a specific development partner, that's been referenced in here, but for these ones, it's the council's intent at present, subject to the outcome of these consultations, for it to be brought forward itself.
So in terms of a development partner and getting a development on board with the sites in that programme, is there anyone or?
Not on this particular site, no. Where there are development partners, I have listed them in here.
Okay. Mr. Tiley?
Exactly the same as the last site included within the short-term development programme of the council. There's no evidence of when completions, that completions will be achieved within 5 years. Nothing akin to the PPG. And once again, if you apply the approach of the Secretary of State, this site wouldn't be considered deliverable.
Any more on this site?
No, thank you.
page 10, Meadvale Shopping Centre.
Yep. Again, another site allocated in 2018. There's clear evidence of progress with this site. A previous pre-application submission was made and a favourable response report was given. And the proposals for delivering residential units alongside the existing commercial uses on an underused car parking area. As I've said, there's further details in Appendix NR4 at page 96. I don't intend to go there or repeat myself.
Okay, so it's, so there is an outline, but it's undetermined. Has there been any indication as to when the reserved matters might proceed?
No, I haven't chased for any information on that site since its inclusion.
Okay. And the trajectory then for this site, where did the figures come from for that?
I believe that, again, that was from a past response on the site. It's not before you, sir. It's nothing. We've only sought to include them where they're the past years' details. They're included within Appendix NR4. But that was based on discussions with the landowner previously.
Right. Ms. Tiley?
Again, I'm going to sound like a parrot. No evidence of completions if you adopt the approach of the Secretary of State. But there are two additional considerations here, sir. Firstly, the current planning application has been modified such that it now provides for a net increase of only 22 homes. In fact, when it was originally submitted, it only provided for a net increase of 27. So I don't understand where the 34 identified by the council has come from. And the second point, sir, is that the outline planning application, the applicants have identified that they can't deliver any affordable housing on site because it would be unviable. Yeah. The council have undertaken a viability assessment and are seeking 21% affordable housing. So there's a significant issue in dispute between the council and the applicant, which will delay the approval of that site in any event. And that's probably it from me, sir. Thank you.
Okay. So the 34, is that?
My understanding was that the application was originally submitted for 34. If there are amended plans, I'm happy to take Mr. Tiley's word for it. I haven't looked at this application personally in recent weeks.
Are you saying that it should be 22 or not?
If it's 22, it should be 22, if there's amended plans.
Okay, do you want to comment on the affordable housing issue?
No, it's not unusual for there to be discussions and negotiations on that. My understanding is that it was suggested it was not viable, which is why the council have commissioned their own viability report in response. I think that's fairly recent. So yes, it's not unusual to have these discussions, and that won't preclude the development from taking place within 5 years.
Is it realistic to assume it to start to deliver 2023? I suppose it doesn't really matter for a site of this size.
No, so again, that was the position, that was where it went in the trajectory, just over a year ago. But given that it's got 2 years beyond that, it's still feasible that that site will come forward within the 5 years, even if that slips slightly.
Mm-hmm. So just to come back on that very briefly, there's an outline planning application that's being considered where there are viability issues in dispute, which commonly, in my experience, take a year to resolve. So let's say outline planning permission granted by the end of this year, let's be optimistic. Thereafterwards, a reserved matters approval needs to be forthcoming. There is it's not wholly unrealistic, the council's trajectory, subject to there being clear evidence that all of that will be resolved. But on the balance of probability, there is a fair likelihood that this will be beyond the 5 years, even if all of those issues are resolved. So.
Is there anything else?
No, thank you.
No.
Just say one thing, sir. As I listen to this evidence, you will know this, but I just put a marker down. Realistic prospect does not mean certain, as you know. And it's all very well shedding doubt here and there. We don't have to prove it's certain. It's just, is it realistic? And for my part, if I may make this suggestion, Mr. Tyler's approach is to look for certainty. he sheds doubt. Okay, fair enough, but that's not the same as realistic.
Okay. Anything else on this site?
No, thank you.
Former Bourneville school site. Again, this is a allocation, flood risk constraints.
It is, but if I could mention,
Yeah.
I've referred in the evidence to the pre-application submission. That includes flood risk assessment and sequential test. So whilst no report has been issued yet, that information is with the council. And on page 99 of my appendix, NR4, it sets out clear email correspondence between myself and Alliance Homes, and that includes an agreed timescale for delivery.
Okay. So, but there's no planning application as yet.
No, it's a pre-application
Yeah,
submission.
okay.
So that includes the reports, again, I won't read them, that I've
Yeah,
listed
yeah,
there.
yeah.
But no, that's in advance of a planning application being
Yeah.
submitted.
The council's not formed a clear view on those studies yet then.
No report has been issued yet, no. No, it was only received in February.
Okay. But the evidence of delivery comes from that pre-app, does it?
Yet the evidence of delivery comes in advance of that pre-app, that email correspondence with Alliance Homes. So my colleagues in the affordable housing team have regular correspondence with Alliance Homes and various avenues of dialogue, and the trajectory I've got in there is supported by that email correspondence with me. I haven't put the date in there, but there is a copy of the email in my appendices.
Yeah. Okay. Mr. Tyler?
So the entirety of dispute on this site is whether or not you have sufficient evidence, or anybody has sufficient evidence to conclude that it will pass the sequential and exceptions test,
Yeah.
and therefore whether it's suitable now, and therefore whether it can contribute to the deliverable supply. Thank you, sir.
Yep. Former Sweet FA site?
Yeah.
Is that how it's...
It was Sweat FA, it was a gym,
Sweet
actually.
FA?
It's
Sweat.
Sweat
Sweat.
FA.
Ah,
It was a gym building. That leads me on nicely to that building has been demolished, and the site is cleared. Favourable pre-application advice was given for the scheme last year, and then there's reference to an email in my evidence, page 100 of NR2. And that's where the trajectory is taken from.
yeah. Mr. Tyler?
Once again, sir, this is a sequential. The only issue between the parties is whether you have
Yeah.
sufficient evidence.
Yeah. Okay. Dolphin Square? So again, is this part of the council's programme?
It is. This site was acquired by the council a couple of months ago, March, that went through, specifically to accelerate delivery of it. So it was allocated back in 2018, and the council have just bought it. So the commissioning plan for the procurement of a developer for this particular site, so this one's kind of one step beyond the sites that we talked about earlier, that was considered by executive in February of this year, with a view to launching the process in the spring and appointing one thereafter. That hasn't yet happened, as far as I'm aware. Again, this trajectory has been provided on the back of that programme by the Council's Head of Development and Placemaking.
So any timeline for the application?
So the timelines are set out in that council report. I think they're referred to in my appendix, but I haven't put the page reference there. Yeah, it's page 103 of Appendix NR4.
Did you say 148?
Sorry, page 103, 103 of Appendix NR4.
Yeah. All right. Okay, is there a developer on board with this one then? Or?
No, that's what's happening at the moment. We're at the stage where they're launching the process to appoint a development partner. That's what was agreed at the February council meeting.
Tiley?
Once again, sir, if you were to adopt the approach of the Secretary of State, this site wouldn't be deliverable. There's no written agreement, and it's a site without even an outline planning application, let alone permission. It's also, sir, if you turn to page 103 of NR4,
Yeah.
Appendix NR4, you'll see the evidence upon which the council rely, which says on the right-hand side of that page, by 31st of March 2024, a start on site, and yet their trajectory has pretty much a 4 years completions in the year 23-24. So they have completions before the site's even started, sir. So therefore the council's evidence is inconsistent with their own trajectory. The additional point on this site is, given the scale of it, start to finish suggests that even without it being a brownfield site, as this site is, it would take 4 years from the submission of an application until the first completion. The council, however, suggests that it will deliver next year, which is just wholly unrealistic, sir, and inconsistent with their own evidence base presented on page 103 of NR4.
Do you want to come back on those points?
So again, the trajectory that stands in this Scott schedule is that from my trajectory, which was prepared a year ago now, the base date for what we're talking about. Given the passage of time, as Mr. Tiley's pointed out, those timescales are in my appendix, and that is the up-to-date version that was ratified in February of this year. Nothing else to say beyond that.
Page 12. Land to the west and to the east of Wembrham Lane. Again, is this another allocation and sequential test? Want to add anything, or should we just accept what we've already said?
Nothing to add.
From my perspective, sir, there's an absence of evidence again in
Yeah.
the Secretary of State's approach, but the principles have all been rehearsed.
Yeah. Nothing to add to that. Okay. Pudding Pie Lane. So outline permission is expired.
Yes. So that initial outline was secured by the landowner. That has expired after 3 years. A new scheme's been drawn up by Stonewood Homes, and there's a recent pre-application submission, and that trajectory has been agreed on the basis of that. The pre-application statement advises that a full application is to be submitted rather than the outline that it benefited from previously.
Do you know when to expect an application?
No, I haven't got a date in front of you, sir.
So the pre-app discussions are live at the moment, are they?
Yes.
Mr. Tiley?
Once again, sir, a site upon which planning permission has expired in the first instance, which suggests the opposite of clear evidence that site completions will be achieved. Secondly, no written agreement. This is a site which is just allocated and therefore the approach of the Secretary of State. And once again, there's simply no evidence that completions will be achieved to my mind. Thank you, sir.
Right, so now on to Western Village. How do you want to tackle this one? Can go through the list. Shall I carry on going through the list, or yeah?
Yeah, we can do. However you prefer to do it.
Yeah. All right then. Locking Parklands then. So the clear evidence then from the council. Do you want to explain to me?
Yeah, so this phase, or this part of the Western Villages development is within the control of Homes England and St Modwen. So it's for 1,450 dwellings in total, and 467 of them have been built to date. Last time the site was surveyed, 90 more were under construction. The trajectory forecasts those completing within a year. This is then followed by an anticipated build rate of 150 homes per year. This is the site that I mentioned in evidence this morning, which is covered by the Locking Parkland stakeholder group. There was the most recent one I personally attended was in November of last year via Zoom with the, I won't read through them, but the various parties, I've listed them in the schedule for you. There was a meeting last month. Unfortunately, I was sat here at a roundtable session, so didn't go to that one. But the most recent update I have from St Modwyn confirmed that trajectory was still valid. And then update from Homes England confirms that the next reserved matters phase has been submitted. There's further details, so I don't intend to read them out in Appendix NR4. There's another reserved matters application under consideration from an additional developer, which is Curo Homes, a local affordable housing provider. And the build rate and the trajectory, I've projected those going forwards and then that additional provider coming in on top.
Okay. And that trajectory, was this discussed at that stakeholder meeting?
Not at the November one, it was validated, if you like. The trajectory was prepared back in April of the preceding year. That would have been informed by discussions at an earlier meeting of that group. These meetings have been quite patchy over the last 2 years with COVID and various social distancing issues. We weren't allowed to attend meetings for a time. A lot were held over Zoom. Some happened at director level rather than officer level to discuss the issues. So they have been patchy in recent times. But that November meeting, which I attended, validated this trajectory.
So they saw those figures for those years?
Yep.
Okay. Mr. Tiley?
I thank Ms Richards for a start in that we can finally find out where the clear evidence has come from, because that was a new representation that hasn't been before the inquiry before. The evidence that has been presented is just an anticipated build rate, but we now learn something entirely new, that it's been validated by the developers. Notwithstanding that, sir, the delivery rate of 150 DPA is unrealistic on this site. To date, over the last 11 years, it's managed roughly 50 per annum. To suggest that that will triple is, to my mind, unrealistic, sir. That would be on a normal development, but obviously at Western Villages, delivery rates are constrained both by market saturation, because we've got a lot of developers delivering in close proximity to one another, and secondly by the employment-led policy requirement on Western Villages, namely that prior to every home being built, the developer needs to have generated 1.5 jobs. So to my mind, it's not realistic, but in addition, there isn't clear evidence. All we have is a trajectory which has apparently been validated by somebody else, but we have no evidence of that, sir.
What page are you referring to in NR4?
It's page 74, sir, I think.
Thank you.
That says pretty much what's in the box, doesn't it?
It does largely, yes.
Yeah. The idea of the point about 150 dwellings per annum being ambitious, do you want to respond to that? Is that based on
Only
number of
insofar as
outlets,
to
or-
say, sorry, so that takes account of an additional developer coming forward, so that Curo Homes Reserved Matters application, which is under consideration.
Could I ask you, Is the 150 validated by developers?
So the 150, this trajectory is a published trajectory, and it gets circulated in advance of these meetings. And in terms of validated, there's nothing published to say it's validated. A part of my job is ongoing dialogue with these people. This trajectory isn't challenged by those developers that form part of it. They have seen it, it's been discussed at these meetings, and it's not challenged.
Right. How clear do you think that is?
I think that's clear evidence that it's unchallenged and therefore supported.
And the only other question I was going to ask, if you don't mind, is Mr. Tyler refers to market saturation at Western Villages. Are you aware of any clear evidence of market saturation at Western Villages?
No.
I mean, I'm not. I don't know where that's come from. I expect there is clear evidence of it somewhere. Mr. Tyler says so, but I haven't seen it.
Yeah, sorry.
Well, I agree. Well, Mr. Talley probably does need some evidence of market saturation. I just wondered if he's got any.
To be clear, these sites there are detailed consents with them. They are part category A and part category B. It's a slightly different.
And I think we are entitled to ask. I mean, it's been asked the council quite a lot. Well, we've got employment-led constraints and market saturation, and I'm just wondering where the evidence of either of those two things are, really.
As Mr. Garvey's correctly set out, the evidential burden falls with the council on these sites, and exactly on all category A sites, bar those very few we've discussed, I've accepted the council's position without any contest. In order to provide balance, the evidential burden on the council I would expect to be applied with the same rigour. And just one other point, sir, is what we've just heard from the council seems to have changed. Initially, we were told that the trajectory has been validated, which implies some implicit support. We're now told it's unchallenged. That's a completely different proposition, I would suggest, sir. And without the evidential basis of any agreement or lack of agreement to that site, I don't know which to take.
Well, why don't we just get the council to clarify how the figures were arrived at again, just very briefly.
Yep, so again, I attend stakeholder meetings with these and other developers and developments. These trajectories were initially drafted and compiled by the council on the basis of going through each individual phase. So what you've got here is Western Villages, Locking Parklands. As is referred to in the column, there's numerous planning applications, and then there's a bigger trajectory beyond that which underpins it with a separate row for each of these developments. So what you're being given is a lump sum for Locking Parklands, that can be broken down into individual phases.
So did you prepare this trajectory and take it to that meeting?
I prepared that trajectory, it having been informed by discussions with that group
So it's
before it.
circulated to the meeting, it's discussed at the meeting?
It would have been circulated in advance of the previous meeting, not this November 2021, so this reflects the most recent one. It was circulated, certainly, to that group of people and has not been challenged. I think rather than, I'm prepared to say that validated is too strong a word. There's no written validation of that, but it was unchallenged by that group of people who informed it and then have subsequently seen it.
So,
Was it discussed at the meeting? Did you say, right, we've got an agenda here, we've sent out the papers, these figures are in it, it's brought to the meeting, is it on the agenda? Was it there to be discussed if anybody...
Housing delivery is discussed as an item, and each of the individual phases were also discussed. So as I've mentioned here, St Modwen confirmed at that November meeting, phases 12A and phase 5 were scheduled to complete within 6 months of that date. Those directly attribute to that 90 dwellings in the first column. So it's built, this trajectory is built from a number of separate rows for each individual phase, and we look at each individually and then come up with a collective figure.
sir, if it's of any use, if I was attending or had been invited to that stakeholder workshop and I was representing one of the developer interests and the council put forward a trajectory to me, my instructions from my clients would be, do not challenge that because it makes us look good. It will help with the approval of subsequent planning applications because they're reliant upon us. So the lack of challenge is entirely unsurprising, sir, because it's in the vested interest of the client, of the developer to not challenge it. So the weight you can afford to that must be viewed in that context, sir, I would suggest.
So just to clarify, so this trajectory is a point of discussion at every one of those meetings.
Housing
is that right?
delivery is a point of discussion at every one of these meetings.
And that is all set out on this trajectory. That's
Yep.
the tool that's used to facilitate the discussion, is it?
Yes, in this particular circumstance, the Locking Parklands stakeholder group, it gets slightly different for each of the different parts of as we go through. But yes, for this Locking Parklands, I sit on that stakeholder meeting. When we prepare a new report, that is circulated to those people. And at these meetings, we discuss housing delivery as a specific topic.
All right. There's no correspondence that says we
No.
agree to these figures, we sign them off, we
No, there's
validated
not.
them or anything like that.
No.
Okay. All right. So, anyone want to say anything about that?
No, sir, I think the respective positions are established.
So the rates at 150 a year,
Yeah.
would that be 2 outlets operating? You mentioned another developer coming on screen, so that would be 2,
On this particular site, it's actually 3.
3. Does anyone want to say anything else about this particular site other than what's on this page?
No, thank you.
No? Page 14. Western Villages, land south of Churchill's Way. It's going to be the same, is it going to be a similar discussion that we're going to have here? So this site would presumably be discussed at the same meeting?
No, this is a separate one in that this site has been brought forward by Mead Realisations. They don't attend that. So the Locking
Right.
Parklands part of the development is a separate one.
Okay, so yeah.
So
okay.
this is directly adjacent to it, part of the wider Western Villages. In hindsight, we should have probably provided you with a map for a bit of context.
Yeah.
But this is another phase, essentially, of the Western Villages strategic development.
Okay, but completely separate, other than perhaps relying on infrastructure.
They rely on the same infrastructure. So the north-south spine road that's going in, for example, will join and run directly through all of these developments. So some of them have Section 106 agreements to link up and join some of these things. But this is, for the purposes of this discussion, should be treated as a separate phase of the development.
So the figures that you've got here, where have they come from then?
So again, this version of the trajectory was drawn up on the basis of what was observed on site initially during COVID. So the outline consent for this, I think, was originally 1,150 homes. And that was secured, as I mentioned, by a local developer, Mead Realisations. Parcels have since been sold on to house builders. Bellway building, Taylor Wimpey have 2 phases coming forward. There were 91 completions in the 2020-21 monitoring year, despite COVID restrictions. And at that time, 323 units were under construction. And therefore, that informed, as I said, we weren't attending and coordinating so many meetings. So on the basis of what was under construction, we've put forward an annual anticipated build rate that was discussed at the council's just internal development forum. And we consider that a conservative build rate, given the significant amount of construction activity that's ongoing at the moment by both Taylor Wimpey and Bellway.
What's the development forum?
So that's just an internal meeting on a Monday morning where issues such as this are discussed.
What, between council officers?
Just council officers, yes.
Yeah.
So things like case officers, strategic development team, some of the consultees, so we discuss sites with ecologists and things like that. So it's just an internal meeting.
Okay. And those officers decided that these build-out rates were appropriate for this site.
So it would start as my piece of work, and that's not to say it's done in isolation. It's done with a team of policy officers, and as I say, we discuss with people like Strategic Development Manager, who has got the applications coming through the pipeline to, is this realistic? Are there sufficient applications coming forward to support this?
And what involvements the developer or the landowner had in those figures then?
So the previous version, a year-old version of the trajectory, we sought information from them. We didn't have any meetings with them on the basis of this trajectory. As I say, due to COVID, we weren't having meetings at that time.
So a year ago, they agreed these figures, did they?
No, sorry. These figures in here, in this version, in past years, we have written to them and had dialogue and come up together jointly with a build rate. For this particular site, these were prepared by me and discussed with council officers.
Then can I ask you, is there a version that has been previously agreed with the developers?
Not for this time period, for this base date, no.
Not for this time, but take last year. When was the last time you agreed a trajectory with the developers for this site?
It would probably be 3 years ago.
3 years ago, so, all right. So 3 years ago you agreed a trajectory. You've not agreed a trajectory since then.
No, for a number of sites.
Never mind the reason. What gives you confidence that this is right? How has it been informed to allow you to come to this inquiry and say, well, I think this is likely to happen? What makes you confident, if you are confident, that this will be the outturn?
I am confident. I visit these sites. As I mentioned, there were, when I last went out, 323 units on this site that were under construction. And it's reasonable, therefore, they're at varying states of being built, to assume that they will come forward over the next 2 years. So that's from 2 developers at the moment. And then beyond that, we've carried on continuing to apply that build rate on the basis of discussions with other council officers, on the basis of the planning applications that are coming through the system. This whole site does benefit from outline consent, reserved matters are in place, and significant construction activity already.
Yeah, so you've got 323 under construction, and what you said is they'll be built
Within 2 years, and
within
then it's
2 years.
reasonable to assume that that will continue going forwards on the basis of the pipeline supply, the discharging of conditions, the applications for reserved matters phases continuing to come through.
All right. Sorry, sir, thank you.
Mr. Tyler, do you want to say anything?
Well, I think we've heard quite clearly from Councillor there that they don't have any clear evidence on this site. And indeed, sir, evidence presented to the Moor Road appeal directly from these developers says that they will only deliver 418 homes from this site. Mead realisations won't deliver any. They're going to replan the delivery, and while they replan their element of the site, they're going to, by the time that happens, it will be beyond the 5-year period. And Taylor Wimpey and Bellway have agreed that they will contribute 418 within the 5-year time frame, sir. So there's actually clear evidence in support of my case, but no, although it's not actually clear because it's not before you, sir, because the evidential burden isn't on me, but there is evidence before the inquiry that my position on this, sorry, not before the inquiry, that my position is correct, sir.
Well, sir, if I could paint a slightly different picture, talk is cheap. What you've got here is bricks and mortar being laid on land and houses being built. You've got houses under construction. If that doesn't give you clear evidence of something that's likely to happen, you wonder what does.
So I should say the sites under construction, the 323 units, we're all agreed those will deliver. There's no dispute on those. It's the residual sites where there is no progress. There aren't bricks and mortars to rely upon, and the developers have said they're not going to deliver.
Well, I'm not sure that that's true. A little bit of common sense would indicate that if you've got 323 houses being built, that Mrs. Richards' evidence is more likely to be right than Mr. Tiley's, but there we go, your form of view, sir.
But there's nothing that you've got in writing from the developers that, if you like, agrees to those figures that
Not for this particular site, sir. As Mr. Tiley said, there's often a different intention from the developers depending on what forum they're attending. So if he were instructed to attend a forum and sell to the council how well things are going, they might give one version of events. Clearly, Section 78 is slightly more adversarial, and it was in the developer's interest perhaps to underplay their delivery rates when that evidence was prepared. But no, I do not, is the short answer.
Just to say, sir, that as I understand it, the developers of this site, Taylor Wimpey, Mead Realisations and Bellway Homes, aren't any of the appellants at the Section 70 appeals, are they?
Mead Realisations were the appellants for the Rectory Farm inquiry.
So do we take that as an endorsement from Mr. Tiley's point, that a developer turning up to a meeting and not challenging something, not endorsing, just not challenging, should be taken with a pinch of salt? Because that's what I took from that.
Provided you add the rider where they have a current Section 78 appeal that they're trying to win.
I'll take what I can from all the facts in the round. This is the only thing that you can do in this exercise, I'm afraid. Okay. Anything else on that site?
No, thank you, sir.
Not from me, sir.
Okay. Western Villages Parklands. Well, that's agreed.
Yes, we're agreed on that one.
The next one, Parklands Mossland. No difference. You agreed on that one as well?
Yes, that's one where there was some debate previously. The outline was for 300 and then the reserve matters came forward for 240 something. We are in agreement on that site. Mm-hmm.
Okay, Mead Fields then?
Yep, so this is the same developer as the one we talked about previously, Mead Realisations. This is just a discrete phase of it. They secured outline consent, as I said earlier. The one we've just talked about was for 1,150. And this one has its own separate outline, so I've recorded it separately for 250 dwellings. The first phase has been purchased by Taylor Wimpey and granted reserve matters consent for 88 dwellings. And we've put forward a build rate for that in the same way as before without going over old ground. I won't repeat myself.
Mr. Tiley?
Yes, and once again, the council have got no clear evidence in support of their build rate. It's based on their assertion, contrary to the findings of Sonning Common et al. And once again, the developers have provided evidence to the Moor Road inquiry that suggests that they will only deliver 88 homes from this site. Within the 5-year period, sorry. Obviously, they'll deliver the remainder there afterwards.
So, the council got any indication as to when the reserved matters application would come in for the...
I think there is, that 250 does have outline consent, and the 88, I believe it does have its reserve matters consent. Yes, it has been issued, the reserve matters for that first 88.
Reserved matters, as you say, for the 88, and then the rest?
I'm not aware, although I haven't checked recently, whether a submission has been made for the next phase.
We don't know.
No, I would need to check. Not that I'm aware of.
And so, again, this was the officers' forum that came up with those delivery rates. You've not agreed them?
They haven't been agreed with the developers. It's treated the same way, what I said about the last one stands.
Yeah. Winterstoke.
Yes, so this is essentially a separate village. What we've looked at up until now are component parts of the Locking Parklands side of the development. And this side is Hayward Village, which is, its scale is 2,550 homes in total. And this site is wholly within Persimmon Homes ownership. I will mention that Persimmon Homes were the appellants for the first and the third of the recent run of inquiries. Anyway, the first outline consent was for 900 dwellings. That then came forward in parcels and is entirely built out. The first completions on that were recorded in 2014. And by April 2021, there were a total of 996 homes across the whole development. So the first phase of 996 from the second outline. All of these figures are listed in the schedule, sir. The second outline is for 1,650 homes. The first reserve matters have been built. The second reserve matters for 375 homes is under construction. Some of those units are already complete. So again, this trajectory was prepared by me and discussed with colleagues. The trajectory includes the remainder of that phase with reserve matters coming forward within years 1 and 2. So the units within year 1, the 147, are already under construction, and the 184 in year 2 is the residual of that reserve matters. Since then, a further reserve matters consent has been issued for another 300 dwellings, which covers the third year in that trajectory. There's significant infrastructure already delivered and more committed. There's a cross-airfield link road, there's a local centre, employment provision, Mr Tiley alluded to earlier, in their Section 106 agreements, the Western Villages developments are delivering employment in line with housing to address an imbalance about commuting within Weston. The first primary school is open, a secondary school is open on the site, and discussions are taking place with my education colleagues for the second primary school and at what point that should be delivered and opened. So again, the build rate beyond the next 2 years is set in there at 250 per year. That's been agreed internally, not with the developers. That's on the basis of previous completion rates on this site. Persimmon Homes did, on their own, achieve 242 units during the 2016-17 monitoring year on this very site.
So have the other years been comparable to that?
There have been peaks and troughs, but there is now more supply with reserve matters consent than ever before.
So what will now make it, what will now make it deliver consistently at its highest ever point?
So again, it was up over 200 for more than 3 years previously, and what we've got here is reflecting the 147 this year were those that were under construction, followed by 184, getting back up to that 250 level now that they've got two phases of over 300, so additional outlets. Previously they've had Charles Church outlets on there as well. There's discussion as to whether that will take place. So different types of product and extra outlets to achieve that higher number at a sustained rate.
How many outlets have you assumed then?
3.
In terms of managing this site, so you mentioned the forum for the other one. Do you have anything similar for this site with the developers?
No.
Regular meetings?
I don't personally for this site. We did have in the past when they were starting to get off the ground and supporting with that. That sort of fell away, being just the one developer. It wasn't considered as necessary for us to pursue this one. I know that regular meetings are held at director level between the Director of Persimmon and the Director of Development and Environment at the Council. And should any issues such as constraints or issues with planning applications arise, then those are then cascaded down from director level. But no, not necessarily a kind of stakeholder forum in the wider sense for this one.
Right. Would those discussions, would they have discussed these sorts of figures and delivery rates?
I'm not aware whether they've discussed these specific figures, no.
So the clear evidence that it's going to deliver that amount is here and in your...
It is, yeah.
Yeah. Mr. Tiley?
Well, thank you, sir. Once again, we've heard that the contribution to the deliverable supply is based on the judgment of the authority, unsupported by any clear evidence. Again, mere assertion, as referenced in the Sonning Common Appeal decision, which cannot be relied upon. The second point, which I think you correctly picked up, is because it delivered 242 dwellings in a single year, that provides no support for a consistent rate of delivery of 250 dwellings. Indeed, the council assume an average of 216 dwellings per annum, which has never been achieved by any site nationally, according to the Start to Finish report, by a single or two development outlets, and it's only been exceeded once by a development with 3 development outlets. Now, the evidence to the Land off Moor Road appeal suggests that Persimmon are only going to operate 1 development outlet at this site, and therefore the trajectory is simply unrealistic, off the scale unrealistic, sir. And indeed, the evidence to the Land off Moor Road appeal from the developers suggests that they will only provide 371 dwellings within the 5-year period, sir. I say only, 371 is still an aspirational delivery rate when you consider Western Villages as a whole, as we'll come on to in a moment.
So, just, you can respond to any of those points, obviously, but if you like, the consistently delivering 250 a year, what is going to change about this site that's going to mean that that's going to happen? Just
So again, with the 2 phases, the 371 units that Mr. Tiley has in the 5 years is only half of actually their Category A figure, their reserved matters consents. So the 242 was achieved in a single year, and again, averaging out this 5-year, and that's not to say that we haven't got the rest of it, crammed into a 5-year period. We accept that this will go beyond the end of the plan period. The 216 that we expect to come forward, average rate over the next 5 years, there's already reserved matters consents to cover the first 3 years of that.
and then this point that I made about why is this site going to deliver this number year on year now, this 250 a year, year on year? What's going to be different about it that mean it's going to now?
Just the multiple phases coming forward, sir, and the level of infrastructure that is there now.
So all the infrastructure's in place, well, not all of it, but what you
Save
say,
for
what
the
you,
second
what you say
primary
there,
school.
yeah.
Yeah.
To ask, when they delivered 242 units in 2016-17,
Yes.
how did they do it, and what makes you think they might do it again consistently?
So again, they had a couple of their reserved matters parcels coming forward that year with different products. So, as I mentioned, a Charles Church outlet, perhaps slightly higher end of the market, and there were phases in there which have flats in them. There's more flats proposed for this second outline phase as well. So the mix of housing types, and they were selling them off plan at the time as well.
Yeah. So it's been done before.
It's been done before, and it can be achieved again.
What was the figure for the year following the 242?
I was wondering if I had that in front of me, and I don't know that I do.
Perhaps we could supply you with that figure in the morning. So
Yeah, it would be helpful to just know. I'll probably find it anyway.
Yeah.
It is,
No
yeah.
doubt. Okay. Anything else on this site?
So, well, no, but I would like to proceed to consider the Western Villages in totality and the realism of all
Yeah.
of those elements together, if that's
Yeah,
acceptable.
well, I'll get to that. If anyone on this specific?
No.
No, thank you, sir.
Right, so what I was going to say, having been through all that, there may be things that you wish wish to just highlight to me, and not wanting to encourage going back over old ground, but some of the points applied across the piece to some sites. So really, I was going to literally just say, is there anything else that you wish to tell me about the sites included on that schedule that you think I should know in terms of, assessing the disputed sites and their contribution to the supply? So that's really, if you've got a point, Mr. Tiley, on Western villages in totality, we can take that now.
Thank you, sir. And this is clearly set out in the schedule on the next page, sir. The council's delivery rates at Locking Parklands are 3 times the average achieved nationally on strategic scale sites of this size, or 50% greater than the greatest rate ever achieved on sites of this size nationally. They're just simply unreal. They're just silly, as I term it in my proof.
Which site did you say?
Locking Parklands, sir.
Locking Parklands.
So that's all of the Locking Parklands elements, all
Yeah.
the phases
Combined, yeah.
together. Similarly, Winterstoke Village, the other village, is 35% greater than the average achieved nationally. Now, even that's highly optimistic and unrealistic to my mind, especially given the employment-led constraints and the comparative market saturation which arises from having such large developments in close proximity to one another. It also assumes, in totality, it assumes a delivery rate of 651 dwellings per annum, which has never been achieved on 2 proximal strategic developments on any site ever nationally. And that's between 175% and 275% of that which has previously been achieved at Western Villages. So it's unrealistic by reference to the past or anything ever nationally. And similarly, sir, the council's previous trajectories for this site have overestimated the supply by between 192 and 268%. So they've been between 3 and 4 times too great. For all of those reasons, sir, it's just, I'm baffled how anybody could contend that these delivery rates are realistic, sir. Thank you.
Do you want to respond to that?
I don't have a lot to say beyond what's already in front of you. I think it's slightly mischaracterised as 2 developments. These are individual discrete phases of a wider allocation. If it would assist you, sir, we can provide an itinerary which the other 3 inspectors were invited initially by the appellants to go out and take a look at these sites. They're just down the road, and it's a red line of these sites with each phase marked on, if it would help you to get some kind of context about how they are distinct parts.
Yeah, I mean, so if I may, Mr. Tiley's lumping together of sites and creating these extraordinary percentages, I just invite you to unpick those lumps by going through the schedule in the way that you're going to go through, and then put those percentages in their proper context, which is errant nonsense. If you lump things together, you do produce those silly numbers. If you look at the sites individually, you get a more sensible picture. I expect Mr. Tiley's going to turn around saying, no, it's you, Mr. Lee, just talking errant nonsense. But, sir, actually, Mr. Richards' last point is right. These are multiple outlets, not 1 or 2 large sites.
Well,
Sorry, just to respond very briefly, sir. The start to finish report considers garden villages, which are exactly the same as these sites. So I'm comparing like with like. It would be entirely wrong to suggest the opposite. And when I'm comparing Western villages with Western villages, it would be entirely wrong to say I'm not comparing like with like, because I'm comparing the developments with themselves. So there is, I fully refute the proposition of Mr. Leader there. So thank you.
Okay. In that, I will go and have a look anyway at this area. It's something that I would usually do anyway. If I'm doing something in the locality and something this big, just generally for my own planning geekiness. So in doing that, if there is a plan that shows the various phases, that's probably going to help me just to get a feel for what this is. Would you have any objection to that being submitted?
I certainly don't have any objection, sir. The one word of caution that I'd have is if you go on site, there will be an awful lot of development taking place, which
Yeah.
we're all agreed is occurring.
Yeah.
But without knowing which parts those
Yeah,
fall into and quite how
let me
it
just
feeds
explain
into
what
that.
I'll be doing. I'll probably be in my car mainly, and I want to be able to look at this map and apply it to what I see from probably Google Maps, just to get a flavour for what this area is that we're talking about, really. I'm not going on site and I'm not monitoring at all. I just want to get a full flavour for these phases that we're talking about. So
Yeah, so it's just a red line boundary, sir, and I'm happy to send it to you in a second. It's got shaded
maybe
areas
give
for
it me
each
with
of
the
these.
site itinerary if you're happy on the last day. Yep.
Thank you.
Does anybody wish to say anything about the deliverability of these sites generally that they haven't had the opportunity to say?
No, I've got nothing to add.
Very briefly so, for closing submissions, what's going to help you? Because when we've gone through sessions like that on 5-year supply, I wouldn't normally go through each of the sites in closing because it's a huge task, but I'm here to help you. So what would help you in that respect, sir?
I think from that discussion I've got a reasonable picture of the sites. I don't necessarily need you to address all of them. If you choose to address a few of them that you feel that need addressing, then do so. That's up to you. But it's not going to help me, I don't think, for you to go through them all again.
I was hoping you'd say that, sir, because like my learned friend, I think, to be frank, if we stick to general principles, sort of matters that was discussed under cross-examination, I suspect that might help you to the extent we're going to help you at all. But just to repeat what you've heard from both witnesses going hammer and tongs doesn't seem to be especially helpful.
No, that's not going to help me. Okay. So, as I said, is there anything that anybody wanted to raise during that session that they haven't had the opportunity to do so? No? No? Okay.
There's a brief point I want to make in advance of tomorrow if it's unrelated to 5-year supply.
All right, well, let's draw a line under this session then. So that concludes the roundtable session on the supply, particularly the disputed deliverable sites. It also concludes the evidence from both sides on housing land supply. Okay, so is there anything else that anybody wishes to draw to my attention?
Yes, thank you, sir. Just in advance of tomorrow, I want to put a document in from the preferred options paper.
Right. What's it needed for?
What this shows, sir, is what the council are planning on delivering.
Yeah.
What their anticipated housing requirement will be, and what they are currently planning to put forward.
Have you seen that document, Mr. Leader?
I have. I'm just looking at the other page where Fred needs to put in was made the correct assertion.
Are you happy for it to be put in?
Absolutely, sir.
Yep. Okay. Yep. I think that's obviously relevant. Yep.
Should we wait till tomorrow if you want to put
No, I'll let you cross-examine my witness and then you'll tell me which page you do. Thank you very much, sir.
Well, is it what?
I've got it in one page, sir.
Well, shall I have it so I can read it?
Yeah, please.
If there's another page, I can obviously read that as well. But thank you. Is there anything else?
Well, only to say this, sir, that the other day you were surprised that I was quite speedy with my heritage witness. I should be even speedier with Mr. Stevenson. So my examination in chief will be considerably less than 1 hour, just so that you know. And I suspect also that my cross-examination of Mr. Wakefield will be somewhat less than 2 hours. So we're going to make good progress tomorrow.
It's the same, so
Okay.
they're not actually a huge amount between providing witnesses, it's how the other witnesses inform their judgment.
Okay. All right. Thank you. That's helpful. We've done pretty well for time over the week, to be fair. So should be. Well, no. It's a joint responsibility, isn't it? Okay. So is there anything else that anybody wishes to draw to my attention? Well, we'll adjourn for the day then at 5:25, and we'll come back tomorrow where we'll deal with both parties' planning evidence.
It's 9:30, is it again tomorrow?
It's 9:30 tomorrow, yeah.
In this room?
Yeah.